and that is fixed on 26 for hearing, Lordship, and is informant and the same, Lordship. Can it item 8, Lordship? Can it be, Lordship, and direction will be given to fix tag with the matter on that is, Lordship, 575/2020, that is fixed on 26/6.
They're not fixing it. Will not fix on 26.
Same petitioner, Lordship.
No, will not fix on 26. If the other matter is on 26, let it be on 26. But this matter, why don't you move this matter? Same petitioner, so what is the harm?
Lordship,
This is a completely bail application, other one is the criminal petition.
Lordship.
So how it is linked to it? Same petitioner, I can understand. No issue.
Same informant, Lordship. Same FIR, Lordship.
Then what is the issue now for bail?
Lordship.
For moving your bail application, what is the issue?
Lordship, and on that day, Lordship, the criminal petition will be disposed of, Lordship, and he's in jail, Lordship. So that is why, Lordship.
He's in jail. Criminal petition will be disposed of.
Disposed of.
Wherein it is listed? This court only.
No, Lordship, by another court, Lordship.
Pardon? Court number?
16. On that day, motion day, Lordship, and that is
court number 16 is dealing with which case? What kind of case?
Earlier occasion, Lordship, I have moved.
Civil law is exactly.
Honorable Justice Midul Golita, Lordship.
Along with.
But notice is a POCSO matter. It's a
POCSO.
My submission, Lordship, same
notice. What about your submission about your notice?
Notice already been served, Lordship, on that criminal petition, Lordship.
In BA,
Otherwise, Lordship.
Every case.
So BA now, this case is at BA stage, it is a motion stage.
Lordship.
So we are otherwise, as per the notification, we are bound to make an order for issuing notice. We'll make an order for issuing notice.
So, and this is 26 maybe, Lordship.
No, we are not fixing on 26. This matter you are saying we'll list accordingly with the criminal petition. Will not allow on 26. If 26 the other matter is it may be come up with 26 on 26. Otherwise, we are not fixing on 26. What we'll do, we'll issue notice to the respondent, a simple order, call for the case diary, and let the request made by so let the matter be accordingly listed along with so.
Charge-sheet matter.
It is a charge-sheeted case. Scan has already
come.
It has come.
So that is why
yes,
it's possible when he is in 46 days in custody.
No. We are not on that. We'll simply pass an order to list the matter along with swear. So that much.
Lordship.
As the PCR already available.
No, it's okay. This thing will look after by the court itself. Heard Mr. F. Dilane Counsel for the petition. Also heard Mr. R.K. Parasha, Dilane Edition PDF bring on behalf of said respondent. Issue notice to the respondent number 2 through the District Police Station. Routed to the office of the registry and the public prosecutor. Also called for the scan TCM. However, at the request made by learned counsel for the petitioner, list the matter along with criminal petition number.
Criminal petition number 575/2026.
575. Public 2026.
As fixed on Lordship and 26/6.
No, it will come up. Okay.
Lordship. Deeply obliged.
Petition number 575 oblique.
Deeply obliged.
Maybe I beg to mention listing irregular bail application on Monday.
Make a mention before court number 8.
Less than 7 years.
No. That is whatever. Court number, we are not taking any mention.
Yes, Lordship.
May I please, your Lordship, I beg to mention item number 22. Let it be fixed after vacation.
It is an AB.
AB.
Yeah, what is the position of 22? CD available?
Yes, it is available. So far as my instruction is court, Lordship, he has already been arrested, Lordship.
Oh, do you have that instruction?
No.
Because this is the arrest memo, Lordship.
Oh. As per our
Interim, the interim is
he
there.
already got arrested.
It becomes infructuous, Lordship.
You don't have any instruction?
No.
But is the arrest memo is there? Your petitioner's name is?
Ibadullah.
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 Is already arrested. Interim was there.
Yes.
Somebody like up to date.
He was arrested perhaps on 7/6, Lordship.
Arrested on?
Perhaps on 7/6.
I guess 7/6.
Yes. Interim was granted.
Five.
5-6.
5-6, Lordship.
5-6.
On the day of your arrest, you have not produced the order or copy of order. You know, you don't have any instruction.
Yes.
Then what to do? He has already got arrested, your matter has already become infractious.
Yes, Lordship.
If you want to take any instruction, you take instruction, we'll dispose of the matter today because keeping the matter for another day will not serve your purpose because he already got arrested. You take the instructions and let us know. Okay,
Alright,
we're keeping
alright.
it for time.
Authorized.
I please your lordship.
So just read. Batch number, huh? Okay, that's sad.
I please
Yes.
your lordship. Lordship, I beg to mention item number 13, lordship.
1-3.
Case diary was called for, but upon instruction, lordship, charge sheet is already been filed, lordship, in this case, item number 13. Scan copy of the TCR may be called for,
So
lordship.
then it will come up in due course. Why are you submitting now? Let it come on due course.
Okay.
Please, your lordship, I'm mentioning a criminal petition, lordship,
Huh?
for criminal petition for listing for order. It was last listed in the year
Make a mention before court
2021.
number 8.
Even lordship, I have approached the registered judicial.
Court
still
number
not,
8, court number 8.
Listed, lordship.
No, you make a mention before
Lordship,
court number 8.
lordship.
No, never have it. Huh? Good. Good. Wait.
I please your lordship.
Yes.
This is NBPS, madam lordship.
NDPS.
NBPS, lordship. 21B. Yes, that may be.
He got arrested on 7th.
7th. See the,
When it can be called for?
my lord, on the 16, 15, 15. Or that is very. Huh? That's it, 15. 15. Say, I got it vote. Okay, what do? And 15, 7.
15. City call. Okay, we're listing it on 15.
Obvious. May it please your lordship. OATC will application, my lord. Petitioner in custody, my lord, 91 days, my lord. And alleged recovery of ganja, my lord, 2,461 gram, my lord. Intermediate quantity, my lord, and charge sheeted, my lord. And now charge has already been framed, lordship. I have annexed the order sheet of the case, lordship. Now again fixed on, my lord, 26, my lord. So, my lord, 91 days, my lord, intermediate quantity, lordship, may consider my bail, lordship.
That's okay, I can understand, but see now, maybe on intermediate, but whether he was a drug peddler, what kind of allegation,
lord,
that we are not known.
FIR is at, my lord.
No, it's okay, we have to penalty scan TCR.
Scan copy, lordship.
Scan
Immediately
copy.
after vacation.
Lordship,
Immediately after vacation, we'll
lordship, if
grab.
possible before vacation, lordship.
Before
No,
vacation.
before vacation, I'm not listing it. No cases listing. List scan copy of the TCR be called for along with the case diary. Registry will do the needful. List the matter, yes, when it can.
14. 16.
16.
Obliged, lordship.
May I please your lordship.
Yes.
Lordship, POCSO 6 is there. CD may be called for.
POCSO.
Yes, lordship.
CDN notice.
Lordship, along with CD, lordship, DNA test report may be called for.
How do you know that DNA profiling?
Lord,
was there?
It's in the CD, it will come, my lord.
No, do you have any information that DNA
Yes,
profiling
yes,
was also there?
lordship, the police collected the blood sample from present petitioner. And lordship, there is one shocking revelation that lordship, the arrested person is not the FIR name accused, lordship. The
Arrested person is not the FIR name.
FIR due to name check, lordship. I was arrested, lordship.
Name check means?
Name check, lordship. Same name, lordship.
Acha, sir, same name.
Yes, yes,
Acha.
lordship.
So you want you are challenging the identity of the person.
Yes, yes, lordship. Lordship, the fact of the case is that one Ashraful Alam lodged an FIR on 23/10/2025, stating that his 13-year-old daughter was illegal illicit relationship with one Dilbar Hussain.
out of which, Lordship, child was born.
Oh, bichara.
Then,
Child
Lordship,
is also born.
after 7 months, Lordship, on 22/5/2026, the present petitioner was arrested and blood sample was collected, Lordship, for DNA test.
Your father name is different. Father name is?
Lordship, in the FIR, there is no father name, only saying that one Dilbar. And my name is Dilwar Hussain. And I am from Bilashipara.
So informant will be able to identify you also, na? Most really, he has already been identified by you.
Lordship, there is a doubt. Or maybe police, maybe there is inability of police to identify the correct person or not. That's why I'm saying that DNA test report may be called for.
You are from Bilashipara.
Yes, yes.
But in the postal, it is mentioned as Kokaviti.
No, I am from Borpeta district. Borpeta district.
Anyway, well, CD has to be, everything has to be revealed from the case there, and if there is a official report from the DNA test, it will come, allow the CD to come.
Okay, we can call for.
Lordship.
But you have to issue notice also.
Notice.
Lordship.
On 22nd July, Malay.
Hello, 20.
Issue notice to the respondent.
There is.
Issue notice to the respondent number 2.
Then
Uh,
24.
Judicial Police Station,
27.
the Office of the
27 July.
Public Prosecutor. And is there a charge sheet case?
No, Lordship.
And also
No,
call for the
Today, 28 days.
case
Investigation is going on.
also call for the case diary along with
27 July.
the DNA profiling report. List the matter accordingly when
27 July one. 27th of July. He won Malay 27. I said 22. So yes,
22, I have a matter in Morigaon, Lordship.
then you can take on 24 also. 24
Yes,
is working day.
Okay.
24.
It's a working day, 24. 24?
Obli-
The petitioner has been in jail since 20 April, but there's POCSO, my lord. So notice, no.
It is charge sheeted case?
No, my lord.
Not sir.
Not yet charge
Not,
sheet.
not yet, sir.
Since when he is in custody?
24, my lord. There are two connected FIRs, my lord. He has been in shown arrest on 20 April.
And the case is also there.
My lord,
Other
there-
cases also there.
two girls had run away from their home. So FIR was lodged for kidnapping. In one case, he has been granted bail. In the other one, it was rejected, my lord.
But you have to take stage for the
Ma'am,
respondent number
my
2. As because it is a FOXO related matter. Obviously, your petitioner is in from jail from 2004.
My lord.
But prior vacation, we don't have any date and we cannot provide you any date also. So let it be, Mr. Parasha, you can try to get the case diary by 13th itself.
Well,
Can it be, will it be possible?
Mal.
13 only very
Ma'am.
working day, reopening day, very
Yes, ma'am.
late.
Obliged.
And you 2-3 days you take just
I
it
think
for the
He takes
respondent.
steps today
Yes,
itself, Malay.
Yes.
Today itself
Yes,
possible. Issue notice to the respondent number 2 through Judicial Police Station. Routed to the Office of the Registry and the Public Prosecutor. Also call for the CD and the additional PP is hereby asked to take all endeavor to bring this CD from concerned police station on or before the next date of listing. List the matter accordingly on 13/7, so and so. We are listing it on.
Deeply open.
Definitely, Your
Yes.
Lordship. Here in this case, petitioner become victim of circumstances, Lordship.
Hmm.
He, along with his fiancée, went to a hotel, Lordship, where police make some raid, Lordship, and along with some other persons, this present petitioner and his girlfriend was picked up by the police. And subsequently, he was forwarded under Immoral Trafficking Act. And the victim, that is alleged victim, she herself, Lordship, submitted before the police that he is my fiancé. Our marriage is fixed in July month, and he has not done anything wrong. And even before the session judge also, she filed one affidavit and appeared before the session judge stating those facts. But his bail application was rejected. In fact, she has also filed one affidavit enclosing she has shown an affidavit which I have enclosed in my petition also.
Page
That
number.
your lordship will find page 17. Start from page 16. They were there, lordship, as he is the fiancé, there for some reason went there, and police make raid, and because of that, this incident.
Where is the girl now?
Girl is outside, lordship.
But
And in fact, if your just one, yeah, just. And if your lordship peruses page 14, this is the bail rejection order. Everything has been disclosed to the trial court, session judge lordship, that her statement was not recorded by police when they found that they were together. All these things has been disclosed, but no reference has been made by the learned session judge. That your lordship may kindly see page 14, last paragraph. The learned advocate for the accused has submitted that he is innocent and he has been falsely implicated in an immoral trafficking case. He was merely visiting a public restaurant with his fiancée so-and-so during an Eid outing ahead of their scheduled July wedding. The police arbitrarily apprehended them from the public place and rushed the accused into judicial custody without even recording the alleged victim's statement, causing severe irreversible damage to their social reputation. Whatever is there, let's say, and already he is in 20 days in custody. In next month, their marriage was scheduled to be solemnized. When anything is there, he will face the trial.
Your FI is at page 9.
Page 9, Lord.
The raid was conducted in one hotel or there
In
are
one
many?
hotel, one hotel, one hotel.
Yes, Parash.
Malad, only one line I have to show, Malad, page 12. That's a forwarding report, Malad. Brief of the case, Malad, 10th line, Malad. Brief of the case, that paragraph, Malad, starting as on 35 to 26, Malad, 10th line, Malad. Victims were allegedly being forced into prosecution by one more. Musaidul Islam, Malad, he is the petitioner. So, Malad, the other part also may be there, Malad. He can say another thing, Malad. So, victims were allegedly being forced into prosecution. Malad. That is, so regarding this, Malad, it is necessary. Malad, this type of activity is going on in that hotel and police got that information earlier and raid on that day. Other total 6 persons were arrested, Malad.
So in
One
that
girl may be
regard, what
fiancé,
is your
Malad.
explanation?
Even if we take it to be true, Lord, I am not saying it is true, but even if we take it true, Lord, then also probably custodial integration is not required at this stage, because he is already 20 days in custody. If there is phone call details so is required, they could have done by this time. And if any other material is required, they might have collected, Lord. 20 days for this allegation probably.
That your this fiancée, she appeared before the learned trial court below?
Yes, she appeared, Lord.
If there is Malad, no other victims, Malad,
Page 15,
that
last
girl-
line, your lordship may kindly see. Page 15, last paragraph. One Srimati so-and-so submitted before this court by one affidavit that accused person is innocent, but the material do not justify such innocence. At this stage, bail prayer cannot be granted. If anything is found, he will face the trial. That is my humble submission before your lordship. And that girl was with him. That part is not disputed by the prosecution, even lordship, by producing the case there is before the learned session there. That part is not negated. That she was not with the present petitioner.
No, maybe matlab, that girl maybe with him, matlab, fiancé, matlab, that is another thing. Matlab, but for involving other girls, that angle is there. Matlab, so to verify that angle without city, matlab, is difficult. Matlab. If there are other girls, matlab, their statements may be available in the city. Matlab.
If other girls is there, also there should be.
And we don't know the other reason, but the
No,
question
but-
is that in the forwarding report, obviously, what Mr. Parashar, he said, the line is there.
Lordship. This line is there,
And
that
that's
I'm
there.
not saying.
That
Lordship.
apart, what if you go
And
by
materials are
the
found by the-
FIR also?
Lordship.
If we go by the FIR also, there also, it is seen that 2 victims rescued and if
Yes,
six
one of the
victims
victims.
so and so.
Yes.
During preliminary inquiry, it was revealed that women were allegedly being forced for prostitution by one Miss Bahadur, your petitioner.
Yes. And
That is
but-
repeatedly
but,
saying not only in the
yes.
forwarding, but
session
the
then also
FIR
made-
itself.
made
Then
transcript
last line
drafted by
also,
him.
during further inquiry,
Hmm.
it was found that one person, namely Mohammad Rakib Ali, so and
Yes,
so,
yeah, Rakib
he
Ali
was
also.
involved in entire nexus, allegedly supplied. And 2 girls were recovered. One of the girl is my fiance, and she has also, Lordship, she is taking steps on my behalf, Lordship. That bail petition is also affidavit is signed by her, Lordship, herself. PG.
No, there is
And
no
only
doubt,
thing is that
there
their
is
marriage is
no doubt.
their marriage is fixed in July. If he remains in custody, it will be not for both parties.
Heard Mr. A. Ahmed, Delani counsel for the petitioner, also heard Mr. K. Parashar, Delani additional PP, appearing on the object response. This is an application under section Swenson in connection with Swenson. It is submitted by Mr. Ahmed that the present petitioner is innocent and he is no way involved in the alleged offense. However, on the day of raid in the particular hotel, the present petitioner along with his fiancée was present there. And when the police make a raid, the present petitioner along with his fiancée who is also picked up from the hotel and she was forwarded in the case of immoral trafficking. He further submitted that the marriage is fixed with the said victim of the his fiancé in the month of July and month of July. And to that regard, she also sworn an affidavit stating that he is innocent and stating that he is innocent and she was along with the present petitioner for a lunch and were going out for a lunch and the eve of day. Eid, sorry. However, the petitioner is in custody since last 20 days and hence, considering his length of detention also, he may be released on bail. He further submitted that the victim of the fiancé of the present petitioner also appeared before the learned session judge and prayed for a bail, but it was not considered by the learned trial court. Accordingly, he submitted that being the permanent resident of his address locality, there is no chance of absconding. Rather, he will extend his cooperation in the further investigation of this case if he is granted with privilege of bail. Next, Mr. Parashar, the learned additional PP raised objection and submitted that there is a clear allegation brought against the present petitioner as to how he is involved in the alleged offense. And as in the forwarding report also, it has been mentioned that the present petitioner is the person who brought the girls and forced for illegal prostitution. Accordingly, Mr. Parashar submitted that Siri may be called for to know the actual fact of the case. Next, we are hearing the submission made by learning counsel for both sides. It is seen that in the FIR as well as in the forwarding report, some allegation has been brought against the present petitioner. But considering the affidavit sworn by the victim herself, who is stated to be the fiancé of the present petitioner, and also considering the length of detention undergone by the accused petitioner, this court is the opinion that some interim bail can be granted to the petitioner till receipt of the case diary. case diary as it is also stated that their marriage ceremony is fixed in the month of July. In view of this, Pakihin Lekidibo, with cooperation, he will be under interim bail. Uh, it has to be called for which place? From which place?
From Nagaon.
Nagaon. 16, 17, and you can
Maybe 21st.
21st of July.
Obliged.
To the satisfaction of CGM Nagaon.
CGM Nagaon.
May I please your lordship?
Yes.
483 application, my lord.
Yes.
Very interesting matter, my lord. What happened, my lord? There is an ad in the Facebook that if you give me 1 lakh, I'll give you double. The boy from Lucknow, UP, he got this, man. Then he followed, he came down to Gauhati and contact this man. He said, all right, you go to Kamakya temple, pray there, I'll hand over you back in the Kamakya temple. So accordingly, the boy has handed over 1 lakh genuine rupee to this very person and accompanied him up to Kamakya temple. There after prayer, my lord, saying that you carry the bag, don't show it and go to the station on your way to your home. Accordingly, with the carrying the bag, he came to the Kamakya station, my lord, and was sitting in a train, my lord. In the window, GRPF has searched the bag and found that there are notes of this counterfeit notes. My lord, out of the counterfeit notes, my lord, what happened? Interestingly, 660 notes of 500 rupees printed in one side. So another 181 notes of 500 printed in both sides. My lord, he has not opened the bag. He has not given it to anybody. He has not utilized the amount. So, though with the hope that he will carry the bag to home, UP, then he will get double amount, but he has been caught by the police and he is detained under 105 days behind the bar. Earlier matter came up before lordship. In the meantime, case was charge sheeted. That's why your lordship directed me to go and approach there. Accordingly, we have prayed before the trial court. Trial court has rejected the prayer. That's why again I have come before your lordship. Now, my lord, in this case, there are the only main criteria, absence of mens rea. He had no mens rea. He has not given it to anybody. He had no knowledge also this thing. Then, my lord, another thing is, he had no knowledge that it was a counterfeit notes. Intention, he has never circulated the amount to anybody. Then attempt to use as a genuine, that was also not done. Then participation in a counterfeit currency record, not there. So, my lord, there is a Supreme Court judgment, Uma Shankar case, very nice, very vital case that mere possession, buying, selling, and receiving counterfeit currency is insufficient unless they accompanied with the requisite mens rea. No evidence of exist showing that the prior knowledge, no attempt to circulate the notes, no transaction involving the counterfeit currency has been attributed. Then, my lord, another judgment, Supreme Court, M. Mahmuti versus State of Kerala. There also the conscious position, guilty knowledge, intention of the use of notes are, I have to be genuine. Knowledge cannot be presumed merely because counterfeit notes were found in possession of the accused. The learned session court interfered mens rea merely because possession of the notes. Delhi High Court judgment, my lord, that is also another Sundarlal. The ordinary person unknowingly came to possession of the counterfeit currency during everyday transaction. The petitioner received the bag from another person after knowing, making a bona fide UPI transfer. The facts indicate that petitioner himself may have been deceived rather than being a participant into the counterfeit currency. Then a violation of section 48 is there, my lord, because he came from UP. 48 notice was sent by electronic media. There is no knowledge or no document or material that it was served to his parents. Then, my lord, our own High Court judgment, my lord, Shahrukh Ali versus State of Assam, regarding the counterfeit, very mere WhatsApp message of communication 48 will not sufficient. Then, my lord, another mechanical error. Ornesh Kumar it was not served upon me in this case because punishment after 7 years. Then, my lord, meanwhile, investigation officer has completed the investigation, charge sheeted, my lord. I will face the trial, my lord, under any condition, 105 days behind the bar. I am one of the foolish person, my lord. So tempted the 1 lakh will give it double money.
My lord, one or two possession of one or two note, my lord, maybe they in daily use, maybe so anyone can get, my lord. Here, my lord, total my lord, value, my lord, it's 4,23,000. 500. And this may be a story for getting double, but here is out of 1 lakh, he get 4 lakh 25,000. And regarding the other contention regarding 48 notices and other things, that has to be verified from the case very and for 4 lakh 25,000 money, he has not taken for placing it showcase. He definitely use it.
If I will use, but I have not used it. If I use, then it could become an offense matter. I have not transacted to anybody.
Verify all this regarding 48 and all this TCR is because
So apart from this other place, we have also taken the plea of 48.
Yes,
Now he is from where?
Uttar Pradesh.
AP.
That's why
How
from
can you
Facebook he
expect-
got this ad. He came and he contacted the man, give him a genuine 1 lakh rupees with the hope that he will get double. He went to the Kamakya temple, prayed there as per his advice, and got this big fake bag.
Can you expect the notice to be served on his parents on the day of his arrest? Can you
My
expect
lord,
that? Can you expect-
I with all due apology, I am submitting because this is the judgment of the apex court, my lord. That's why I am submitting.
No, 40 is okay. More, of course, can you expect
But no,
his
that
parents
was-
to be
yes, by
provided
electronic
with
media.
notice 48?
I mean,
to
our own
stay
high
here?
court, our own high court.
Yes,
Shahrukh
they
Ali's
have-
case, judgment, our own high court judgment.
Okay, we'll call for the scanty here. We don't have any alternative. Your correct submission may be correct. I won't deny it. And there may be some lapses in the part of while issuing notice under 48. Have you taken the dose plea before the session judge?
Yes, everything.
That matter is.
Earlier also, when I matter came up your lordship, I took this plea also.
Acha.
Well, only thing is, well, I have not circulated to anybody. Given me
The
back, I
question
have
of,
taken.
the mens rea is there, but we
Huh?
don't know at this stage what is the purpose, what the investigation reveal against you, whether there was any mens rea on the what conduct.
That is no man's say, I have not given it to anybody. If I circulated it,
Why you have taken this entire bag of money?
well, if I circulated it, I have not, there is no evidence that I have given it to anybody. Or I tried to transact it to anybody.
We'll call for this scanties here. But Mr. Biswas, prior vacation is not at all possible. We'll take immediately after vacation, we'll try it. This will come from which place?
From Kamru?
From Kamubattu only, na? 13 by 14 detail.
Well,
13 itself.
Before vacation, if possible.
No, we are not listing anything.
Or
else.
anyway, during vacation court, I will try.
Then,
Vacation code I will try.
you can make a mention before the registry only, but we cannot fix any date. The instruction not to fix any date because long list will be there.
Well,
for the
105 days I have already completed.
Yes, I can understand. That's why I
When will be the
thought that
vacation
it
code
will be
that
better on 13.
notification also not come?
Pardon?
So when will be the vacation code that notification also not yet come? And
Brother, you will get the notification by
No,
before
cannot-
vacation.
we cannot-
Don't worry for that. Vacation code will be definitely there.
Yes, will be there. I don't know for how many days, maybe
Yes.
1 or 2 days. But in that case, you can make a mention before the registry also.
Sure, I'll do.
So we are listing on 13 because, but if in meantime you can manage, then we'll get it listed before
Well,
vacation.
if your
bench.
lordship fix a date after vacation, then even if I mention, it will not come. That
Then
is the
what to-
problem.
Then what to say, what to do?
Then any day after 28, if CD won't come, 28 is the last code, I think.
No,
26.
26, let it come.
no, we are not listing anything
Well,
prior to vacation.
Kamrup here.
No, we are not listing. That is special instruction, not listing anything. All exclusively for the motion week. No matter is listed. We're not listing anything. It will be listed on immediately after vacation, that is on 13. Or if you want to say that if the date is fixed, there may be problem for you to get it listed before vacation bench, then why we won't give any date. After vacation, we'll do then.
Anyway, the court will say why you are preponing the date. There is a fixed date from the court. All these things will come up.
That's
again.
why before vacation, can I say?
Yes,
Sorry, not before vacation. I'm just after vacation.
yes, ma'am.
After vacation,
You
we are not
list it after
fixing any
vacation,
date.
madam.
Not fixing any date.
No, I'll bring it, madam.
Okay, then it is. So and so, all for the case there, however, at the request, made by the learned. Call for the TCS, can TCR, registry will do the need. However, considering the request made by learned counsel for the petitioner, let the matter be listed after vacation as when it need to be fixed by the minister. Okay, then you try it. এই ময়ে ইমান টানকে ক'ব লগা হৈছে দেখাইও কৈছে please দেখ বঢ়িয়া দিছে ঠিক কৰক নহয় চব চলিব কি মানে এনেকুৱা চলিব আৰু এনি 4 লাখ টকাৰ বিক্ৰী নি Yes,
In
Mr.
this matter, Lordship, from a hotel, my lord, suspected cook beef was seized, my lord, by the police.
Suspected
Cook beef, my lord.
or cook beef?
My lord,
Acha.
from a hotel, and we are the owner and the cook of the hotel, my lord. So my contention is that, my lord, we have been arrested prematurely, my lord, because, my lord, only the FSL can confirm it. As per my instruction, it was not beef, it was mutton. And in fact, it has been sent, my lord. Kindly come to page number 12, my lord, of the FIR.
Yes.
Para number 4, my lord. Forensic
Ah.
confirmation sought. A representative sample of the seized meat is being forwarded for forensic veterinary laboratory examination for specific species identification to scientifically confirm whether the seized meat is beef within the meaning of so-and-so, my lord, of the cattle slaughter is prohibited under the act. So, my lord,
This
without,
cook beef was recovered from your house hotel?
no, my lord, from hotel.
Oh, hotel is situated where?
My lord, it is in market area, my lord, from the kitchen, my lord, and it was not exposed for any sale.
What is the name of your hotel?
Taj Hotel, my lord. Is only suspected, my lord. My lord, what is my contention, my lord? After confirmation, at least we should have been arrested. For the time being, my lord, the hotel should have been sealed. And my instruction is that it was not. So without confirming that, my lord, we have been arrested. And
Confirmation definitely will take some time, I think.
yes, my lord.
Then,
My lord,
then how will you be arrested, or if you fled away, or if anything had happened in between?
yes, my lord. And at that midnight, my lord, the raid was conducted. And it is also very doubtful, my lord.
So you used to serve the people with beef meat.
No, my lord. No.
Then why you cooked beef in your hotel?
It is not beef, my lord. It was not beef. It was mutton. And they have suspect, and there is business rivalry, my lord. There are lots of other hotels also there. So some wrong information might have been given. And at the midnight, my lord, this raid was conducted, where there was no any customer, man. And from the kitchen, not from any from a person which I have served, man. So it was never exposed for, even if we assume that it is beef, my lord, it was never exposed for any sale, man, in contravention of section 8 of the act. Man.
Sale means you're selling the cooked beef meat
No.
in the hotel only. If those beef meat is served to, suppose any customers with the impression that it is a suppose mutton,
Man.
then what will happen? Then what will happen?
That's why I'm saying, my lord, it has to be confirmed first. Then we should have been arrested, my lord. Without confirming, my lord.
Otherwise, it is difficult to say also, my lord, but during the seizure, videography and all this has been done. Though it is in night hours, videography of the seizure, all proceedings.
Formalities were there.
Videograph, my lord.
I'm not denying that, my lord. Only regarding the species, whether it was beef or not, my lord. We are not flying away anywhere, my lord. If there is suspicion, the hotel should have been sealed, my lord. It was not done.
Mr. Parasar, we are not listing any matters prior vacation. The question is that I don't know whether it's a beef meat or mutton
If-
as
if
he is
not, my lord.
committed. So let try once to get the CD on 25th itself. Just try it.
My lord,
If it receives by 25, it's okay. Otherwise, it will be a date fixed.
my lord.
We'll try it.
Yes, if it is
Otherwise,
confirmed, my
we
lord,
have
then-
heard earlier, we
Yes.
have not listing any matters.
But-
But as you have submitted that it may be a mutton or without any,
Yes, yes, ma'am.
that
That
may
is
be
my
there.
Yes. If it is
But
confirmed,
obviously,
then
there was specific information. Otherwise, how especially your hotel will be
My
conducting
lord,
inquiry?
but-
There
there
many
are, my
hotels
lord,
in the
because
area.
I'm running the hotel very well, my lord. There is business rivalry. Other hotels are also there, my lord.
It's a very serious
Without any
thing. If you
information in midnight.
serve the beef meat with the other follower of the other religion,
Yes, yes,
then it is very
definitely.
serious.
If it is confirmed, my lord, I
Very
don't,
serious
I don't
case,
have
my
any case.
raw meat is that too can be accepted, but cooked beef meat will be very serious concern. Na? We should have CD call for along with the FSL report. Processed equity. Okay, 25th.
25th.
Obliged.
Why this is a deal? How?
May I please, your lordship? The allegation is lordship, the petitioner transporting a cattle, lordship, which are stolen property. Lordship.
Transporting cattle
Lordship,
illegally.
I have annexed all the relevant documents, lordship, the invoices, of the original, lordship.
Now, who are you?
The
You are the
petitioner are the
handyman.
driver and handyman of the vehicle.
You are the driver and handyman.
Driver and handyman of the vehicle. The alleged vehicle as well as the cattle were seized by the investigation agency, lordship.
You got arrested when? 8th of
8th
June.
8th of June, lordship.
How many cattle were recovered?
53 number. This is a big
53
container.
numbers of cattle in one vehicle, my lord. Can
It's a
imagine.
big container vehicle, lordship.
Big
Truck.
container maybe, my lord, but 53 numbers. Cruelty, my lord, how it,
They are the
At the
driver and
time of
handyman.
your
Of
arrest, you could not produce anything.
At the time, I produced, lordship. I produced before the investigation agency, but FIR itself saying that I have not produced any documents, lordship.
No, but now you have produced some documents, like we can see.
Oh.
But at the time of your arrest, no documents were available with you.
Documents-
Although I have produced the same, but FIR itself showing that I have not produced, lordship.
That's why I'm saying. But then we don't have any alternative. You got arrested on 8/6, na?
8/6, lord.
Then
Mainly the vehicle as well as the cattle were seized, lordship.
Seized.
The problem is that
No, all
a long
all
vacation
matters
is
we
here,
cannot
lordship.
accommodate prior vacation. It's not at all possible for us. For 13, 14, kiba paribo, maybe? Person,
Lordship, kindly
13,
consider this.
13 or 14.
13 or 14?
Lordship, kindly consider at this system itself. lordship.
14, 14, 7.
They are the driver and handyman only. no?
Yes, we know. 14, 7. How you can get for 53 numbers of cattle?
It's a big container.
What kind of container? Just tell us.
A very big container, lordship, which carry
What kind of container? Is it a vehicle, container, carrying any? What is it?
As per the rule, my lord, around 1 square meter has to be provided for each cow, my lord.
No. What is the vehicle? What
facility.
kind of vehicle it was?
pretty big size vehicle,
No.
truck
What
vehicle.
what
lordship.
kind of vehicle?
It was a truck, lordship.
Truck.
Truck, lord.
Big truck.
Big truck.
Achha. Not container. Big truck.
Big truck. Which carries the container.
Long truck
Where
maybe,
is
my lord, but
Containers were there.
Container.
Truck or without container?
Na container carrier truck, lordship.
Container carrier.
Container carrier.
Okay, we'll see to it.
Kindly consider, lordship.
No.
Bless you.
May I please, your lordship? Your lordship, the respondent number 2 herein has lodged an complaint before the CJM Darang, whereby the FIR, after the order, the FIR was registered. The allegations against me, all the petitioners herein that is that. May I, your lordship? Page 24 is the relevant portion.
Yes.
para number 2, on November so-and-so date at about so-and-so time, taking advantage of the complainant's absence from her house, the accused number 1 mentioned before below illegally entered the complainant's house. He repeatedly and forcefully raped the complainant's minor daughter, Miss so-and-so, aged 17 years, currently a student of class 10, against her will. Later, when the girl started screaming and shouting, he gagged her mouth to keep her.
Yes, Parasha.
My lord, as per FIR, my lord, except petitioner number 1, for others, PROCEED will not come. my lord.
Yeah. And
Seems to be.
yes.
Others, PROCEED will not.
And at this stage, I'm praying for interim relief of the other accused. The accused number 1 is not required, but interim for other petitioners.
Heard Mr.
M.R. Sodial.
Sodial, Lilanet counsel for the petition. Also heard Mr. K.K. Parashi, Lilanet petition PP, appearing again. This is an application, the section so and so, issue notice on the respondent number 2 through jurisdiction police station, rotate to the officer to register and the public proceeding. Considering this submission made by Lani Council for both sets, matters in the case check, especially the statement made in the FIR. This court is of opinion that some interim protection may be provided to the petitioner number 2, 3, 4, 5, 6, 7, and 8, namely so and so, so and so, so and so respectively. Will receive possibly this time. However, prayer for interim protection for the respondent number 1, petition number 1 is not considered a station. Also call for the case that disseminate when it can. Other petitions will be under interim protection. 1, we are not get rid,
Yes,
and the issue notice to the respondent
Yes.
1 also.
And notice registered post. Yeah.
No,
Both
through
ways.
jurisdiction police station,
Oh,
rotate to
through
the
police
office of the
station.
registry and the
Oh,
public.
so this, okay. Raised it. 21st of July.
21st of July.
Deeply obliged.
May I please, Your Lordship? The pre-arrest bail application, Lordship. Lordship, initially the FIR was registered under section 87 of the BNS. Subsequently, on the prayer of the IO, section 6 of the POCSO Act was added, Lordship. Lordship, may I kindly see the FIR for a moment at page number, Lordship, 12. 1, 2.
Yes.
May I read the FIR?
Ah.
I, Rajesh Sharma, is the informant, son of so-and-so, resident of Rajendranagar, near Sabun Factory, Tinsukia, would like to state that my minor daughter, namely Rani Sharma, aged about 17 years, has been missing from our house since 15/4.
To the office of the registry and the public prosecutor, and also call for the case that list the matter accordingly. Yes, when it can be listed?
16, 16, no, 16.
16/7. Okay, 16/7, we are listing it.
Kindly consider,
No
Lordship.
protection. Okay, 16/7.
Obliged.
Please, your lordship, engaged counsel is on legs. Matter may be taken after some time.
Okay, we'll see to it.
May I please, Your Lordship?
Charge sheet submitted, Lordship.
Yes.
Submitted.
There was call for Lordship in this case. Charge sheet has been submitted, Lordship. LCR may be called for Lordship.
You want to get the LCR?
LCR, Lordship.
Heard Mr. D. Mehti, Dilani counsel for the petition. Also heard Mr. Anandas, Dilani, KK Das, Dilani petition BP appearing on behalf of the respondent. Case was fixed for case diary, but it is submitted by Mr. Das. That case has already been charge sheeted. Yes, why CS number?
CS number, Lordship, 61/2026, dated 30/04/2026.
However, Mr. Mehdi, Dilani counsel for the petitioner submitted that the scan TCR may be called for and the bail application may be considered. In view of this, the registry is thereby directed to call for the scan TCR from the concerned court along with the case there. List the matter accordingly. Now see, it will take some time because we are not in a position to say anything where it is pending.
Now,
What is
Lordship,
the case number?
Kamrup Metro Special NDPS Court, Kamrup Metro, Lordship. Now it is only one court.
Whatever. 17/7.
17, Lordship.
17/7.
Can it be little bit earlier?
Little
On
bit.
the 7? Oh, sir, it's okay. Deeply obliged.
Are anyone want?
May I please, Lord?
Yes, what is the position of 14? CD receipt? Yes, Mr. Ali.
May I please, Lord?
Yes.
My lord, the petitioner, my lord, he was arrested, my lord, on 24/4/2026, my lord, at 6 p.m., my lord.
Just a s-
Your Lordship,
just a second. 24/4?
24/4/2026,
Yes.
at around 6 p.m., my lord.
Mm.
And your Lordship, in the FIR, my lord, page 15, from page 20, my lord, FIR, long FIR filed the police, and regarding apprehension on page 23, my lord, regarding arrest. Charge was started from, my lord, 24/4/2026 at 2:30 p.m. They received the information immediately, and on 3:30 p.m., my lord, they started, my lord, is the place of occurrence. As per FIR, my lord, page 20. And case is registered, my lord, under section, my lord, 21B, 22C. And he was produced, my lord, on 26/4/2025. Forwarding report, my lord, page 41. Here they have shown, my lord, the arrest date and time of arrest on 25/4/26, 6 p.m.
Yes.
So, Lord, as per FIR, my lord, he was arrested on 24, my lord. He was kept in police station, then shown arrest on the subsequent date. And he is in custody. And forwarded, my lord, next day, my lord, on 26/4.
Yes.
So, my lord, he was kept in the police station for 24 years, more than 24 years, my lord, without, my lord, producing before any magistrate. And this is the legal issue involved in this case, my lord. And in this point, my lord, this all the Honorable Supreme Court order, my lord, I have given, my lord. And your Lordship also relied this order in one bail application. That was also I have given. And this Honorable Court has also passed order, my lord, we have annexed, my lord, Annexure 5. Annexure 6, my lord,
At page?
at page 50. And almost all the coordinate benches has been allowed bail on this point, my lord, holding that the arrest is illegal, violation of Article 21. Okay, by the
Okay. So that is the main issue.
Lordship.
When he watched 24/6.
Right.
24, oh sorry, 20,
24/4
from April. April,
Lordship, April
Achha.
24.
Anyway, okay. Yes, Mr.
My lord, regarding the materials in this case, my lord, he is a my lord, Bhutan drug dealer, my lord. Total seized, my lord, may kindly note, Yaba tablet 966 gram, heroin 9.62 gram. Cash amount rupees, my lord, 20,23,520.
Cash,
Cash,
20 lakh.
20,23,520. And also fake currency, 1,34,000. From the my lord, tenant room produced by the wife, Runa বিশ্বাস, my lord, his wife. Other items and some other items, mobiles and all this, these are there, my lord. Moreover, he is a person who earlier arrested in such NDPS case, one of Howley PS case number 125 of 23.
Howley PS,
Yes, yes, Howley PS 125 of 2023.
for similar kind of offense?
NDPS. Holai PS 41 of 2025.
Just a second. Holai.
Holai. And Borpeta PS
Holai PS, what is number?
41. 41 of
41
2025.
20.
And Borpeta PS case number 116 of 2026. That is there. And now, my lord, as per the arrest memo, my lord, he was, so these materials are seized, but he is formally arrested, my lord, on 25th, my lord, in the page 40 of the petition. Arrest memo, date and time of arrest, 25th April 2026 at 6 p.m. And it was produced on the next day, that is on 26, before 6 p.m., before 24 hours. And case is very premature stage, commercial quantity with fake currency on a huge amount of money, arrested on 25th April. Now we are on to 19th of June, my lord. Not more than 2 months.
It's okay. Commercial quantity, use quantity, that these are okay. These are not on his submission also. He's basically hampering with the one of the legal aspect that he was produced before the court after a lapse of 24 hours. That
My
is
lord,
his submission.
as per arrest memo, it is shown as 25th of April at 6 p.m. my lord. In the arrest memo, formally. My lord, some articles were seized as per MR number 51 and other MR also there are 68 of 2026. Those were seized from from his wife on 24th. But he was formally arrested only on 25th for 2026. The arrest memo itself, my lord, and that about the first production order, I'll let us speak, 26 for order, I'll discuss that order of the. Five. No. 19, not 19, 26 for no. But that order, I am not getting that order. Or other orders from sessions as perhaps it is produced before CGM. The CGM order is not available, man. That order of.
Be available. You have called for the entire record is there.
maybe in the legal stage, my lord, but I'll trust that order, my lord. Because my lord, order 22/5, that is a special judgment. I don't think. Well, after some results, I'll trust that order. That order is necessary, my lord, for production order. Everything has to be, my lord, from that order, production order, my lord.
Can be clear, can be no there. Legal. Huh? No. দেখে পারবে কোনো দেখে গভর্নমেন্টে ভালো আছে আমি রাখি তো ছিল ini দিয়ে দিব
My please, your lordship. Regular bail lordship. The FIR was lodged on lordship 11/9/2025 regarding theft of money from the informant. And there are later on lordship, later on lordship on 8/5/2026 lordship that they were arrested. More than lordship, near a year lordship, 11/9/2025.
no FIR was lodged on
11/9/2025 lordship regarding the allegation that money was stolen from his possession, that he was kept in a scooter and by the people that has been taken over by the informant. Later on lordship in the on 8/5/2006 he saw those person roaming nearby. As he have looked into that CC camera, CCTV footage, he have identified that person, and thereafter, after 8-9 months, he have seen those person, and they have took and informed the police, and now we are 43 days behind the bar lordship. Further custodial detention.
recovery was there any
No recovery. Almost lordship, it is month of September 2025, and we are arrested in May lordship. That say 8 months or 9 months like that. No recovery was there. And looking at the CCTV footage, he have identified the informant. He caught them and informed the police lordship.
Yes, lordship. What had happened that, as my learned friend has already stated the facts, lordship. The thing is that on 11/9/2025, this person, the informant, took out lordship 11,60,000 lordship, out of which 6 lakhs he has put in the scooter lordship, and it was locked. And he had a shop in front of some place. He has a camera also lordship. So that from that scooter lordship, this person has took out 6 lakhs. And later on, police has also found that FR has been given and stated that no further clue has been given. But though there is a camera is there, lordship, CCTV footage is there. But in the meantime, lordship, on 7/5/2026, this person, these 2 persons, lordship, the present petitioner, they were loitering in the bank premises, lordship. And this person also happened to bring, lordship, money from the bank, SBI bank premises, lordship. Then he have identified these 2 persons, lordship, and he has called the police, lordship. Police has came and arrested these 2 persons. And lordship, after arresting this person, they have not given their identity also. When asked about their identity, they are giving different names and the different places, lordship, and they have not given the identity card also. Later on, lordship, they were arrested, and they have also stated that in their statement, lordship, they come from West Bengal to these places and loitering around these places suspiciously. They are looking around these bank places, lordship, ATMs and like this. And
On the basis of these 2 persons, other 3 persons are also arrested, Lordship. Because police made aware of that local area, Lordship, after knowing that they are from West Bengal and other persons are involved, other persons are also involved. So for the other persons arrested, and their interrogation is necessary, Lordship, to trace out the whole gang, Lordship. So investigation is going on in this ground, on this town, Lordship. So it is very essential for this custody interrogation. It is at the crucial stage of the investigation, Lord.
43 days, Lordship. Father, once they have filed the final report, Lordship, they are again revived, Lordship, when they were arrested. I'm not with that, Lordship. 43 days, Lordship, any condition maybe will appear, Lordship.
Because during 45 days, he was
60
not
days
there,
mandatory,
Lordship.
Lordship.
He was not there because they were not, he cannot identify because he is not known to this person's Lordship. When he is identified in the, he has also look into the CD, Lordship. Oh, sorry, Lordship, CCTV. Then he can recognize this person. And they
That
also
is-
stated that they coming from West Bengal.
That is in the FIR itself, Lordship, the CCTV footage.
So Lordship, they are involved in this case. And not only this, Lordship, they are loitering around. Other persons are also in stake, Lordship.
That evidence will say, Lordship, at the time of trial.
At this
was
stage,
there.
Lordship.
Group was there.
Group, Lordship.
No, 2%.
Because other persons are also there, Lordship. Other persons are arrested after this Lordship is arresting on 22/5. Other persons are also there. 3 persons.
43
Investigation
days,
is going on,
Lordship, of 60 days statutory period, Lordship. Vacation, so there are 40. Any stringent condition, Lordship, we will make ourselves available. Now
be
everything
difficult,
is in
Lordship.
their.
They were from West Bengal, Lordship, it's difficult.
That is not a crime, Lordship.
Since it is 60 days,
Lordship.
Lordship, offense.
43 days, Lordship, in the custody, and thereafter everything is there, Lordship.
At this stage, Lordship, it is difficult. Because it's a group, not a single 2 persons, Lordship. Otherwise, I would not, Lordship. It's a group. It is very necessary to nab this person.
Now, how long they
And
can? How long, Lordship? Beyond 60 days, Lordship, nothing can be
No,
done, Lordship.
we will.
They have given enough time, Lordship.
Default bail,
43 days.
definitely they will get, Lordship.
43 days, Lordship,
But
enough time.
statutory, we are given this right, Lordship, to interrogate, Lordship.
43 days, Lordship, their father, they have not sought any.
Heard Mr. Espone, the learned counsel for the petitioner. Also heard Mr. Brigadier, the learned additional PP, agreeing on status. This is an application under section so and so, connection with so and so, stated.
So 60 days will be very,
It is submitted by Mr. Munir that the present accused petitioner. The FIR of the case was lodged on 11/9/2025. And after 7, 8, 9 months later, the present petitioner got arrested on 8/5/2026 on being identified from the CCTV footage. It was the allegation that 6 lakhs rupees was stolen from the scooty of the informant. And however, the police could not trace out the petitioner, and subsequently he got arrested and was in custody since last 3 days. Mr. Munir accordingly submitted that petitioner is in custody since last 43 days, and hence, considering his length of detention, he may be released on bail. However, he is ready and willing to extend their cooperation in further investigation of this investigation of this case if they are granted the privilege of. Mr. Das, the learned additional PP, raised an objection and submitted that the fact that the FIR was closed on 11/9/2025, but thereafter no clue was found for the accused persons. But on 7/5/2026, when these 2 persons were found loitering near a bank with a view to do similar kind of offense, the informant could identify the 2 petitioners, and they were subsequently confirmed that through the CCTV footage, as these 2 are the petitioners, these 2 are the persons who were involved in the alleged offense. On the basis of their statement made by these petitioners, 3 other accused persons also got arrested in this case. And the case is at the very crucial stage of investigation, where the entire gang is the police is trying to nab the entire gang of the offense. Further, he submitted that initially these 2 petitioners did not disclose their identity, and there was difficult on the part of the police also to nabbed these two persons, but subsequently they got arrested, and hence he submitted that to nab the other persons or they can. The custodial interrogation of the present petitioner is very much essential for the purpose of investigation, who hails from the other state of West Bengal. Other state, that is West Bengal. Thus, the probability of absconding of the petitioners also cannot be denied at this stage. But considering the submission made by learned counsel for both sides made in the case diary and the submission made by learned petition PP regarding their involvement in the alleged offense, and this court is of obtained that further custodial interrogation may be necessary for the purpose of investigation. In view of this, the petition stands rejected. Your petition stands rejected. Rejected.
Much obliged, Your Lordship. Much obliged. Much.
Obviously, they go to the Naiku Nukra Monte with them. It will have to take the phone of my data. নাই নাই এইটো মই আমাকে অফ হৈ যাব কিমান কিমান আৰু কি বহুত চাবমিশ্যন এনেকুৱা নহয় নহয় আৰু আজি যদিও দেখিছে আপুনি কমপ্লিট চবটো চাবমিশ্যন আছে Yes, I will find this.
My lord, yes, order.
Okay.
My lord, this order and my lord. That's the order, my lord. Nothing has been mentioned that he is arrested.
Statement. Nothing is.
Just placed people. On that day, it was not mentioned by his advocate was there on that day. Regarding 48 and all this are discussed by the court, but whether he was produced after
Beyond
24 hours, that aspect was not there in that order.
Heard Mr. R. Ali, the learned counsel for the petitioner. Also heard. You flagged the relevant area. I'll have to peruse the question.
My lord.
This has been flagged. Other also.
Others,
I will give. R. Ali, the learned counsel for the petitioner. Also heard Mr. K.K. Prasad, the learned additional PP appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. CD received, bill received. Next part, it is submitted by Mr. Ali that the FR of this case was lodged on 24/4/2026 at about 6 p.m. And on the day of, on the same day at about 3:30 p.m., the search was conducted. And some contraband was alleged to have been found from the person of the accused petition. However, the petitioner was shown to be arrested formally on 25/4/2026, and he was produced before the trial court on 26/4/2026 as 26 post-op. Thus, the petitioner was kept in the police custody beyond 24 hours without being produced before the concerned court, which violates the article, which violates the right of the accused petitioner under Article 21 of the Constitution. Mr. Ali basically states on this law point, and it is also submitted that the courted bench of this court, as well as the Town and Apex Court, had dealt with the this law point, wherein the bail applications were granted, considering that the beyond a period of 24 hours, detention of a accused petitioner beyond the period of 24 hours is illegal, and which violates the article rights granted under Article 21 of the Constitution. Next, Mr. Parashar, the learned petitioner PP. Out of the petitioner is in custody. As per you, he is in custody since when?
Since, my lord, he was forwarded on 26/4. Today, my lord, 55 days.
Further that apart, the accused petitioner is in custody since last 54 days, and considering his period of incarceration, also he may be released on bail. However, being the permanent resident, he will extend his cooperation in further investigation of this case as and when his cooperation will be required. Next para. Mr. Busher, not Busher, but Mr. Parasha, Dilanet additional PP, raised payment objection and submitted that this is a veteran drug dealer, and from his position, huge quantity of the contraband, including the Yaba tablets, were recovered. Yaba tablets were recovered from his position, and that upon a cash amount of rupees 23,23,520 were also recovered from his position, apart from the other materials. He further submitted that some fake currency notes amounting to rupees 1,34,000 is also being recovered from the position of the present petitioner. Mr. Parashar further submitted that the present petitioner is also involved similar kind of offense, and 3 numbers of cases are also pending against the present petitioner, namely Howley PS case number 125 of 2023, Holai PS case number 41 of 2025, and Borpeta PS case number 116 of 2026. Mr. Parashar further submitted that the formal arrest was done on 25/4/2026, and within 24 hours, he was produced before the learned trial court bill. However, after receipt of an FIR, some search operation was conducted, and some materials were also recovered or seized from the position of the wife of the accused petitioner. He further submitted that no illegality has been committed for protection of the present accused petitioner. That apart, all the formalities were duly observed at the time of his arrest. Mr. Prasher accordingly raised objection and submitted that considering the nature of offense alleged against the petitioner, his earlier conduct, and other aspects of the case, the prayer for the petitioner may not be considered at this stage. Accordingly, read for. Will pass the order, I have to peruse the case diary.
Plus.
Yes, you just mark it. Mark it at 60. Not of taking it by 11 or 11:30, but it is almost 12 now. So we'll take up your matter, I think, because there are other matters. They may not be, won't be.
So what's your lordship proposal, my lord? So that we can also manage our thing, my lord.
We'll take the matter first. There are 2 matters left as per the schedule, 16 and 17
After
matters.
2 matter, we can start with it.
After 2 matters, we'll try by 12:10.
Sure, madam. We'll be here.
Okay. Because it will take some time on the second half also, it may run.
Oh, my.
So, okay. Other matters, I don't know whether it will be reached on.
I have-
Let us see. Okay, see, we'll see.
Watch.
Case 17, it's a charge sheeted case.
Yes, charge sheeted case. Else,
She's here for
Here has been
call for-
called
we have
for that we
received.
have received, Lordship.
By the way, just asking you, at what is the stage of the case at present?
it is
Charge has been
at
framed.
the stage of evidence, my lord. Charge was framed on 29th of April. And today is itself is the date now
For
for
evidence.
evidence.
Not, but we do not have the recent status, Lordship, because whether it has taken place or not, we do not know.
No, what nature of case you're saying?
My lord,
Fake Indian currency note.
fake
fake
Indian
Indian
currency.
currency.
yes.
That was recovered from his
Position.
position, Lordship, was caught red-handed by the RPF staff.
My
And
lord. Here, petitioner is an advocate by profession. So I have given a total explanation that he had received that amount from a client. And eventually, or it is unfortunately discovered as a fake currency. So I have stated all the specs. And he was arrested on 4/12/2025. Now it is more than 6 months in incarceration. So I am relying on a Supreme Court. Honorable
It's
Supreme
okay,
Court.
but
Yes.
what we are on,
My lord.
he may be innocent, we are not on that. But undoubtedly, the fake currency were recovered from his position.
Right.
Charge has already been framed in this
Already
case.
framed.
Lordship, that is on, Lordship,
29th of
29th
April.
of April, 2026. Lordship.
For evidence.
Yes, now it is now it is fixed for, today is fixed for evidence. Lordship.
Evidence.
Then what to do?
Lordship, this is a serious offense, Lordship.
No, that's why I'm saying, I thought that if any evidence was there, that
No,
we
no,
can have a.
no evidence is, we have received actually. Only today, only we have received.
lord,
In that case,
otherwise-
what we'll do,
My lord.
we'll fix a date after vacation
Yes.
and we'll call for an updated status of the
Status
case. But
report.
because from your submission, what you have submitted, it was this submission in the earlier also same submission that he is an advocate, somehow he
Yes.
was.
Earlier on, my lord, before
But
this,
that will not suffice because
No.
the case is a very serious
my
individual.
lord,
That
earlier on,
from an advocate.
since before this honorable court, since such sheet was submitted, so it was by this honorable court directed to approach the trial court. So
trial court order you have
that order
annexed?
was not on merit, my lord, by this honorable court.
Trial court order you have annexed?
Yes, I have annexed. He has.
But I think that at least 1-2 evidence should be there before us. Otherwise,
My lord,
how will we see-
otherwise, honorable Supreme Court has held that there is no possibility that this trial would be finished in a very reasonable time. It may take time. So since investigation
see, there are
is
both way,
completed,
the
such
judgments are in the both way.
My-
One says long incarceration may not be the only method. Is
and-
very.
Let
And in
the
some
relevant
other
witnesses
cases, there
get
is-
some
there is no
reasonable
antecedents of
But now reasonable period, there's a question of reasonable period.
my lord.
He is in 6 months, so case has already been charged and
More than
case is
6
fixed for evidence. So we cannot at this stage, it is a long incarceration or violating your
Nothing is, nothing is.
right under Article 21 at this stage.
My lord.
But that's why I'm thought that at least the present status can be called for. Or,
Yes, Lordship.
My lord.
okay, then it will help to us to some extent.
Yes.
He wasn't practicing advocate from which part?
Yes, at Jabalpur High Court, Madhya Pradesh. He belongs.
This high court.
Yes, yes.
He came for this purpose only.
Yes, he has a client from Indore and he resides in Assam. So at the time when he visiting this my lord client, he
That
also
client is already arrested.
client there
happened
is
to him?
although he has mentioned before the police that he had received from such and such person, but I think there is no arrest being made
Yes. Lordship.
on
That is
that
the-
link, my lord.
So good ground for you because if the client had cheated you, then no, definitely there was a case.
You can file a fire against the client.
He has
Anyway,
mentioned his
okay.
name.
Heard Mr. Siddharth, also for the petition, also heard as asset work. So and so, scanticia has already been seen. But this is not an updated one. And there is no record as to whether any evidence has been recorded by the learned trial court below. In view of this, let a present status report be called for. And the learned
Authorization.
court had already, of course, court also directed to furnish the evidence, copy of the certificate, copy of the evidence along with this present status report, if already recorded. The registry will do the needful in calling the present status report along with the evidence of BW's. Let the matter be accordingly listed. So one date is today, na?
Lordship.
Yes.
Who is best? 21. Mr. Das, can it be on 21, 22?
Yes, ma'am. Because for
21.
yes.
21.
21.
Publish, publish.
Wait one second.
May it pleases my lord.
Yes.
Today this bill application is fixed for hearing.
Can you increase your volume from your side?
Milords, am I audible, milords?
You are audible, but sometimes your voice becomes so low. So
Oh,
maintain this voice. We can hear it. Now I can hear you.
Very well, milords. I'm really
Because
sorry.
you are on through VC, we are hearing you, na. So better we have to
Yes.
hear all these things. And by the way, have you filed your additional affidavit also?
Yes, milords, we have
It has
filed.
already been filed.
Yes, it has been filed and
A copy
served.
has already been served.
Yes,
Let me send the same.
Okay.
please.
Yes, you can start.
Yes, milords, I will try to be very brief, milords.
Yes.
And keeping in mind that my lords know all the facts also, since my lords have already seen the bail application of a
May it please
co-accused.
lordship. May it please lordship. The sound is not audible.
Need you to go so wherever it problem. Your pipe. From our side is okay.
Yes,
From,
yeah.
yes, but
Yes.
but from
Yes. Am I audible to the PP also, milords?
yes, we are,
Oh, yes,
it's
my lord, I'm
possible.
getting it. Now,
Now it is okay. Now it is okay.
Yes.
audible only, not video.
Video is not there.
Oh.
Video is not there. Hey, for video analysis.
Sir, I can't see you too. Milords, there is no video on your side too, sir.
Try to dictate. Mr. Kamar, we are just starting it. You just hear his voice audible. He is audible more or less.
It was.
We're trying to get the things. Okay, then yes, Mr. Yes.
Yes, please, my lord. So I will be only on the triple test for the bail, my lord.
Yes. Triple
First,
test.
yes.
Yes.
Yes, milords. The first, milords, whether there is a prima facie case.
Yes.
Second, that if I may misuse the liberty, if milords exercise milords the direction, milords discretion.
Misuse the liberty, and then 3.
3 is the witness tampering. And 4th, which is important, milords, because milords, I have also facing this issue, that whether the community sentiment or a public outcry can be a ground to reject the bail.
Emotional and sentimental.
Yes. Yes. Now, milords, first of all, if my lord will see the impugned order, milords, if milords will have the impugned order, I'm sorry, milords, I'll just come there to the impugned order. Yes, the impugned order, milords, after the entire it starts at
Annexure 3, page 62.
yes, I am much obliged to my learned friend. page 62. This was passed on 4th May 2026. The learned trial court, my lords, the fast track court, gives its reasoning, my lords, which starts at please, my lords, I'll just which starts at my lords again page 73. In fact, it starts at page 71 at the bottom. I have considered the submissions of the learned counsel for the parties and perused the material on record and the decision relied by the respective counsel for the parties to arrive at just decision of the bail petition. Now let me go through the facts and material of the case. Now, according to the trial court, my lords, trial court's understanding, the prosecution case is given in nutshell that accused A1, A2, A3 hatched conspiracy to eliminate late Shri Jubin Garg at Gauhati. Now, this is very important, my lords, because in my respectable
Mr. Mishra, you are
as
not.
on today, my lords, I'm sorry, my lords.
There was an interruption. Now, yes, now we can start.
Yes, my lord, something my lords wanted to ask.
No, it's okay. You are not audible at the time. That's why.
Okay, my lords, I'll repeat. This sentence that a conspiracy was hatched at Gauhati is without any basis. My lords, there is no material on record to show conspiracy was hatched at Gauhati or even a conspiracy was there. There is no material on record. I am saying it at the outset, my lords. Then, my lords, I'll read, my lords, page 72, fifth line from the top, sixth line. Accordingly, A1 being manager, A2, my lords, I am not concerned, invite fixed program at Singapore and took deceased to Singapore and then gave bottle of whiskey by A2, fed alcohol to him through A4, knowing his health condition on the night of 18th September, and thereafter, after that, without medical and security arrangement, allowed him to go for yacht tour and then allowed him to enter into water, and finally due to heavy intoxication deceased died by drowning, and accused persons caused death of the deceased by knowing fully well that deceased was a patient of epilepsy and suffered seizures 4 times, and last being in the month of May 2025, and deceased was restrained by doctor to go to water bodies, fire and bathroom door be kept open when enter in bathroom, and A1 was present every time when deceased was hospitalized, and doctors given direction to family members of the deceased, his wife, manager A1, who signed, there is a grammatical, who signed consent form of the deceased treatment, and his friends, but even then deceased was given bottle of alcohol, fed alcohol, and then allowed to enter sea to swim. A1 and A3 misappropriated the money of the deceased. Now this is separate misappropriation. Currently, Milords, I will address arguments only on whether there is a prima facie evidence for conspiracy and the murder charge, Milords. Now, Milords, page 73. I have perused the statements of the LWs from the statement of listed witnesses and documents, digital paper documents submitted along with the charge sheet of the instant case by the investigating agency. Following points emerged against accused Siddharth Sharma. A1. Statement of LW doctors pointed accused A1 accompanied late singer Jubin Garg to the hospital as and when situation arose, it should be. Late singer suffered seizure, epilepsy. A1 put his signature on the consent form of the patient's treatment. Doctor specifically advised him to take care of late singer Jubin Garg. He was told by the doctor that late singer be regularly provided with the medicine prescribed to him. He be restrained to go to water and fire, and door of the bathroom must be kept open. He should not serve and be fed alcohol. A1 has specific knowledge of the health issue of the deceased and guidelines, advice, direction to him, and follow up action, and to take care of late singer from his ends. Milos, not to take care is important, and I am Milos stressing on that. Then, para 9. LW statement and relied documents of prosecution pointed A1 is the manager of late singer, and he managed everything of late singer, and deceased suffered from 4 seizure attacks and last seizure in the month of May 2025. A1 was advised and directed by the doctor to take care of him, and A1 managed every aspect of late singers. He fixed all tour, including foreign country program of A1, fixed tour and program fees, prices, and took him to Singapore without doing prior health checkup before departure to Singapore, and without obtaining fitness certificate to fly abroad from the treating doctor of Nemcare Hospital as required. Being deceased was patients of epilepsy and suffered seizure 4 times and in public place also, and last one in May 2025. Now, Milords may also mark as required, because it is again my respectful submission that there is no material and nothing on record to show that it was as required to my client to take care of all those things, to get a fitness certificate. 10. After arrival at Hotel Pan Pacific, A1 took documents from all team members, including the late singer, to do the necessary formality for hotel stay, and at that moment, he with A2 changed the room accommodation of late singer with A4 in place of one Anuj Barua as per earlier arrangement. A4 was inducted in the room of late singer at Pan Pacific Hotel only after arrival at the hotel to fed alcohol. Milords, this sentence does not make any sense. But what I can understand that it says that A4 was put in the room of the deceased in order to feed him alcohol. This is what this sentence means. Then 11. It is within his knowledge and his presence. A2 gave one bottle of black and white whiskey to late singer on 17/9/25 at the lobby of the Pan Pacific Hotel. He did not restrain or forbid the act of A2, which fed the deceased on the intervening night of 18th and 19th September. Now, again, a duty is cast upon me, milords, without there being any material to show that there was a duty on me to restrain or forbid the act of A2 to give a bottle to the deceased. In the
You
impugned,
are the manager.
I am the
You are
manager.
the manager. So manager
Yes.
and every responsibility was on you, I think.
Milords.
So in
No,
that case
no.
also, do you think that A2 should not be restrained by A1 while
Milords,
offering
Mil-
the bottle of
Mil-
whiskey?
Milords, then if the duty to care, Milords, under the new BNS Act, if it extends to that level, Milos, if it is interpreted that being a manager, a servant, Milos, who is appointed to take care of his official tours, programs, and everything, would it also include his personal care? More so when he is an adult, he is in good sense of things,
Okay.
and he is not under any legal guardianship. Because it has to be seen very minutely, milords, it is my humble submission
Yes. No, you can.
that this duty to care has to be understood in a proper context, milords. Now, 12.
Yes.
A1 was present when LW87 was discussing about the yacht tour with late singer, where other team members, A2 and others, present at hotel lobby, but A1 not appraise the organizer of yacht tour being manager of deceased about the health issue, direction given to him by doctors of deceased. Now, next, LW87 asked to bring own foods and only basic drink, but no hard drink. Avon told him that he too will bring drinks and food. Avon took swimming costume, and it was Avon, A3 and A5 who changed dress and go to swim first, and Avon has prior information and knowledge about all the water activity that would carry on 1909, but not informed LW87 that deceased was restrained from to go to water. Now, next, my lords. LW87 made contact with A1 and the deceased after getting message from organizer A2 in their WhatsApp group about NEFI Singapore on 31st August to be held from 19/9 to 22nd September. And then he discussed about the tour of late singer and other activity with A1 also. Discussion on yacht trip was held from 17/9/25 at hotel lobby, and LW93 offered proposal of marina better than yacht trip, and A1 was present but not nodded the proposal of LW93 when yacht trip was finalized in the presence of A1. Because again, this is a conjecture. Yes, if Milos, I can't be foisted on a responsibility that if someone other proposes other things, then I have to nod on that. And therefore, I did not nod. Therefore, I hatched a conspiracy. Milos, it is, it is, it is not even a circumstantial evidence to Milos foist a charge on me. Then, when yacht trip was finalized in presence of A1 not disclosed about medical history of late singer Jubin Garg to them. Then material and oral statements revealed A1 was well acquainted about giving of bottle of alcohol to Jubin Garg by A2, not restrained and follow the doctor's instruction and direction, and allowed the deceased to consume alcohol at the bar, then in the Pan Pacific Hotel, and paid the cost of alcohol of the restaurant, and then allowed him to drink before boarding yacht, and during traveling in the yacht allowed him to drink beer, not restrained, and informed others NRI about doctor's direction given to him regarding prohibition of alcohol consumption to late singer, being manager of the late singer, and doctor's specific instruction to him to keep away late singer from consuming alcohol, water, and fire. It is the statement of LW 96 that organizer of yacht party LW 87 briefed all not to serve alcohol to deceased. Now this is again contradictory, Milords, because at one point says LW 87 was not informed, and then the other part, Milords, the trial court says LW 87 briefed everyone not to serve alcohol to deceased. Then, Milords, A1 was present in the restaurant on 18/9 and paid the bills of whiskey and dinner of 18/9 amounting to $400 in cash to witness LW 87, telling him he do not have credit card, and witness paid this amount to restaurant by credit card, and he has clear specific information about the consumption of black and white by late singer till late night, that is to say intervening night of 18/9 to 19/9, but did not take any steps to restrain the singer every time alcohol served on deceased in presence and knowledge of A1, but he never restrained as per the statements of LW. A1 fixed dates, managed, now it is my role which the trial court discusses. Carry on all tour, events, performance of late singer, and date fixed for this tour is also held with him by A2, and he has information about the Singapore to be held in the month of September prior to the premiere show of Bhai Monda, that is to say last season of late singer, and having contact with A2. A1 was present when captain of the yacht giving safety briefing, but he did not inform the captain and other LWs about the medical health issue of deceased. But in the same breath, the trial court also says that LW 87, who was the organizer, he briefed everyone that not to give alcohol to the deceased. About the medical health issue of disease, that disease suffered epilepsy seizure, and last one in the month of 25 made further statement of LW present on record is that he with A3 and A5 jumped into water first, and when late singer jumped into water in the second time without life jacket after being fatigued, A1 was kayaking nearby, but even not raised any hue and cry or follow disease to bring back him. No help from A1 come immediately. rather engaged with cacaing and do not come forward on call made by other LWs, although the LW83 present with him moves first for the help of disease. So what I could understand from this sentence, Milos, there was no break in the sentence. Grammatically, it's wrong. So what it means says that the accused, my client, went to the water first and he was in the water, but he did not stop the deceased the second time. When he was second time jumping into the water, that you are not wearing life jacket. Thirdly, when he was deceased was fatigued, the accused did not do anything to save him. It doesn't say he was nearby or do anything, but it says, this paragraph says that other LWs reached to save the deceased, but the A1 did not rush to save the deceased. Then, as per material on record, when alcohol served to late singer, he did not restrain, rather, he also consumed alcohol with all in front of late singer and not disclosed that doctor prohibited late singer from consuming alcohol, and he was directed to follow up the direction of the doctor and to take care and to look after same. Milos, it is then, Milords, I'll page 78. Statement of Bihu committee witnesses is that during Bihu program of 25, at the time of fixing fees for the Bihu show, A1 told Bihu committee that this is the last program of the late singer. Now, Milords, this becomes how, because I asked this question to myself, that I am saying that this is my last appearance in, say, Patna High Court. I may not be appearing in Patna High Court from tomorrow onwards. Would that be a circumstance against me for murder of someone or ending of my career? Because my statement saying that this might be a last program of the singer becomes a circumstance according to the trial court. Then 21, Milords. Statement of the witness is that the A1 asked to prepare a last tour of late singer. LW stated LW present in the yacht asked A1 to catch late singer in second time, but according to eyewitness, he took time to take out the deceased from water. Milords, the two sentences are mixed, so I don't know. It says that he took time. Otherwise, the material on the record shows that the captain of the yacht, who was responsible, he took the deceased out of the water. Then A1 asked accountant of deceased to pay an amount of rupees 70 lakhs and received the same from the accountant by inflating amount in the name of payment to the builder of Khargoli house of late singer, and builder confirmed that he received only rupees so and so from A1, and A1 siphoned the money of late singer and routed to his account and his family member account, and then invested in his personal project, Hotel Mahavir Aqua Manpara flat. So this again is another Milos for which I am charged. Then a statement of listed witnesses pointed vehicle arrangement for late singer's live show are the vehicles of A1. These are all my financial Milos discussion on which right now Milos I am not even seeing anything. Then 24 also I will skip Milords. Then 25. At page 80. Please, my lords.
Yes, page 80.
Yes. Page 80, 25. Now, this is important. Material available on record pointed A1 kept belonging of late singer in his possession after death and not hand over to family members immediately on arrival to India. Deceased mobile contained valuable documents, but A1 kept the same with him till the police seized the same from him. Not contact police, which is wrong, I'll show, and investigating agency, even when Ejahar was lodged against him, and hide in different places of India, such as Delhi, Rajasthan, etc., after coming India from Singapore. Milords, I'll show from the material which I have filed that this is not true at all. The prosecution, the investigating agency, they have suppressed this material from the court, milords. Then, upon perusal of entire material on record, it is clearly apparent that A1 having first-hand information about health issue of disease, duty bestowed upon him to look after, monitor, and manage deceased victim in all respect, fixed all program, including foreign country program, took deceased to Singapore without undergoing prior medical checkup as required, and by not complying doctor's direction given to him, and allowed deceased to drink, then pay prices of drink, last minute change room arrangement of deceased with A4, not follow conform doctor's direction, not informed others about the restriction and direction given to him by doctor to be followed with the deceased, and led deceased to enter sea water under influence of heavy alcohol with blood ethanol present in body so and so amount in stupor condition, saying jabode jabode, not restrained deceased to go to sea water, misappropriated huge amount of money of deceased, and then invested in own profit business. Incident took place when deceased told that he will take account of his income from A1, keeping belonging of deceased till police seized from him after his arrest, not appearing before investigating agency soon after arrival in India on 20th September by flight number so and so, and then changing his place of stay, pointed there is strong incriminating material against him of his commission of the offense alleged against him. If accused A1 is released on bail, there is possibility of influencing the witness and hampering of the further progress of the case. Third, there is every possibility of him flying away, which is appearing from the past conduct of the accused. Then the milords judgments are given, and then next page, page 29 is milords again repetition of the same at paragraph 28, 26. So I'll skip that for the Miller's time. Now Miller's. Two, three things. Please. Now, if Milord will permit me, may I give a brief timeline of events, Milords. 19th September, the unfortunate incidents happened in Singapore. 20th September, an FIR is registered. 20th to 22 September, Milords, there was funeral, and the Milords deceased was brought from Singapore. The accused A1 also came back along with him. On 26th September, now, a notice was served on me under 179 BNSS, directing me to join investigation on 6th October as a witness. Now, if Milords will permit me to show the additional document volume first, Milords. This notice in the additional document volume is at page 100.
Page?
100. 100.
Yes.
Has Milord got that? This
Yes.
is the original copy. Now, this is addressed by CIDPS to me at my residential address in Assam and also sent on my email. Now it says two important things. The case is registered under 61(2), 105, culpable homicide not amounting to murder, and 1061, which is, Milords, is Milords negligence. Now, in this notice, I was called at the Milords police station on 6th October 2025. To this, Milords, I write a reply, which was never put on record by the investigating agency, Milords. At page 120. Twenty-ninth at page 120, my lords. I'm sorry.
Yes.
This is my reply on 29th September to the notice of the CID. I write, Milords, allow me to read it. To Dr. Roji Kalita, Senior SP, Crime Investigation Department, Police Station, Ulubari, Gauhati, Assam. Subject, reply to notice to witness, serial number so and so, concerning FIR under so and so. Respected Madam, I am writing in response to the notice to witness under section 179 served upon me, Siddharth Sharma, son of so and so. At the outset, I would like to submit that I am fully willing to cooperate with the investigation regarding the tragic death of late singer Jubin Garg and provide all facts truthfully known to me. I fully understand the seriousness of the matter and wish for a swift and just resolution. For clarity, I would like to state that I am willing and available to participate in the investigation. However, in view of the serious and immediate threats to my life, which makes it unsafe for me to appear in Guwahati, Assam I would request you to ensure my and my family's safety. I am fully ready to cooperate with the investigation and willing to submit any documents and evidence in my possession which are necessary or available to ensure proper interrogation and thorough investigation. I sincerely hope that CID SIT will consider my request with the utmost seriousness so that I can fully cooperate with the investigation without risking my life. Sincerely, Siddharth Sharma. And it also shows at the bottom the trail of mail that CID at the rate assampolice.gov.in had attached the notice. So this was in reply to that email. Now, Milos, since we are at the additional document volume, I would like to show some documents, Milos. Now, it has been said that I have I have run away. I did not cooperate and I was hiding. Where the fact is that I was the person who was doing all arrangements, making all arrangements from Singapore till Delhi when the officers of Assam government took the deceased on a flight. Now, at page 101 is provisional clearance certificate. This again is in my name that annexure 4, page 101. This is e-clearance for afterlife remains in Singapore. Now, again, I was the person to whom this was entrusted, the deceased was entrusted. I was there. Then, Milord's next 102, it is again me for the casket service. Then from the High Commission of India, I took the certificates. Then page 104, the information is by me. Then the certificate of death. Every document, Milords, I was managing. I did not run away. I was managing for the legendary singer to bring him back to India. The even to the plane, the consignment, page 109 was consignee name was mine. I was the consignee. Nobody asked me, milords, for the documents, the passport, because I was the one managing. I did not run away from Singapore to another country. I came back with him. But since there was a special plane arranged for the body of the deceased to be taken to Assam, I was told that you come later since there is a threat to your life. There was a huge public outcry, and I was made an accused already in the public eye, a media trial, milords. Now, the most important thing, milords, is at page 113.
Page?
113, 113
Of the additional.
of
Yes.
the additional document volume
Yes.
is the arrest memo, my arrest memo. Now, this arrest memo at page 117, 117, milords will see, I was arrested on 1st October. Now, if milords will remember, my lord had seen the notice to appear was for 6th October. Now, what happened on 29th after receiving my reply that I am willing to cooperate. I am willing to do everything what the investigating agency wants me to do. What happened that there was a rush to arrest me even before giving me time to appear on 6th. On 1st October, as per police, that I am arrested at the Assam airport, Gauhati airport, I'm sorry. Nothing is mentioned that whether I was coming voluntarily or I was arrested from Gurgaon and then brought there. Why this hurry to arrest me before my appearance date, milords? Now I'll show the reason also, milords, for the prosecution.
Okay, we'll continue at 2.
2. Much obliged.
Miss Bora, there are some matters I think I have seen, AB methods.
Lordship.
May not be possible also.
Lordship.
Now the question is that well, they all are in interim.
Lordship, there are cases.
Now 20 is one AB.
Lordship, item number 21.
21, yes, 21.
Affidavit CD was called for along with the injury report that we have not received.
Not received.
Not received.
They are on interim?
They are not on interim, Lordship.
They are not on interim.
Not on interim.
Okay, then I don't know if it reaches, then we may hear.
Although it was rejected by Lordship.
Okay.
Yes.
Then without period of the case, there may not be possible.
The CD is available, but injury report is not.
Injury report.
Yes.
In connection with item number 21.
Lordship, item
21,
number
counsel is not
21.
here now at present he is not here.
Lordship, 21. It was rejected on 15/5/2026, Lordship.
No, the counsel is not here.
Yes. 22.
Yes, what is 22?
22.
It is on interim, Lordship.
You are on interim.
Yeah.
Otherwise CD receipt.
CD receipt.
CD receipt.
So we'll extend your interim.
Lordship.
Okay. 22 to you.
Always memo to.
Yes, yes.
Positive.
So there is one more confusion, Lordship. I have submitted that arrest memo was served upon the petitioner, but thereafter he has been released on bail bond, appropriate bail bond, Lordship. And his statement is recorded. But, Lordship, so far it was allegations regarding physical assault upon the victim with lethal weapons. And we have accordingly received the injury report. And injury report says grievous injury by blunt weapon, Lordship.
Whatever, we are not in a position to hear the matter.
Yes, Lordship.
So let it
Let it be on interim, Lordship. Let the matter be fixed after vacation.
Positive record will be. However, it was submitted by MS CDBC. As CDB return calling for an updated one along with the injury report. And is the matter according to when it can be listed.
Let it be on 22nd.
22nd, Lordship. Interim be continued. What about 20?
Lordship, 20, Lordship.
20 counsel is not there.
Lordship, only report was called for. Whether any case has been registered against the petitioner, but the counsel is absent.
As per what your report says?
Report says, Lordship, no such case has been registered against the petitioner, Naushad Ali Ahmed, Lordship.
Naushad Ali. In
Yes.
which police station?
Is Bongaigaon PS, Lordship.
Interim was there any?
No interim because only a report was sought for.
Oh. No other no proceedings actions as such kind of interim was not there.
Yes, no.
Okay, then none appears on call. Item 20 will matter. No, none appears on call for the petition. However, it is submitted by MS Bora, the Land Administration PP. That report received from which police station?
His Lordship, it's Bongaigaon PS, Lordship.
Bongaigaon.
Yes.
Bongaigaon PS, stating that no case has been registered against the petitioner under the Bongaigaon police station. Let the
Lordship will fix the matter after vacation also because petitioner is absent.
Let the matter be accordingly kept with the record, be listed. After 15?
15, Lordship, obliged.
Report be kept.
Lordship?
Report be kept to the case record.
Yes, Lordship.
Report be kept as a part of it. 23, what is the position?
Yes, 23, Lordship. 23 also, Lordship. It is regarding yes, it's also regarding whether any case has been registered against the petitioner. It's from Borpeta PS, Lordship. Because the report is awaited, Lordship. Yeah.
Apit.
Yeah.
Was there any corrective action like interim was there?
There is a report is there, Lordship. The report cannot be submitted as only GD entry number is mentioned, but no date of occurrence is mentioned in the order.
No, we are not supposed to make any mention in the order. No, I'm not on that.
Yeah.
I'm asking whether there is any interim order was there.
Lordship. No interim was there, Lordship.
Huh? No, interim was there. Right?
Interim was there. Oh, Lordship, we do not. We're not aware.
No, yes, no, interim was there. So report is awaited.
Report is awaited.
It will be one number, item 22. 23. You are MS?
Arkha.
MS Arkhan. Appearing for the petition, also MS SH Bora. Report is awaited. PhD matter accordingly on 16/7/2026. awaiting the report from the police station. Interim be extended till next. Yes, what is the position of 24?
Lordship 24, Lordship,
Mr. Just I'm taking some time.
Yeah, no problem, madam. No
Just
problem.
40 matters are left. That's why I thought that.
Yes,
we
yes.
after it.
24, Lordship, CD was called for that we have not received, and it's a POXO matter, Lordship. Service report is also not awaited, Lordship.
Yes, Mr.
Yeah.
Gogoi, the service report is still awaited.
Yes, Lordship.
And we have not received the
Case diary, Lordship.
case diary also. So it will be definitely fixed after the vacation.
Lordship.
Okay.
Lordship, immediately
But-
after the vacation.
Yes, heard Mr. J.C. Gogoi through VC, and also heard Ms. S.H. Bora, so and so. C did not receive further the services still awaited for the respond number. Let the matter be accordingly listed 17.7. Issue reminder for CD 17.7 corridor. Service be awaited till next time.
Highly obliged. Obliged, Lordship.
Your Lordship, Senior Advocate Commerce, he's on trial now, so he's coming. So kindly timing for him.
Timing to for your this case, we are clearing the other matters only.
No, he's on his way only.
So you
He-
sit it?
Yes, I'll be.
Will be.
Yes.
Will accept
I'll-
you also
yes.
be here.
Yes, let him his
Let-
part
let-
be finished.
okay, yes, no issue. And 21 was 21 luxury. 21.
Your Lordship, your Lordship earlier rejected, my lord. Today, my lord, after 1 month we have come. To our information, everything complete, my lord. Investigation complete, my lord. 60 days, my lord, statute 60 days. Today, 45 days, my lord, in custody, my lord. We came earlier, your Lordship, 19 days was there, my lord. And your Lordship
Yeah,
passed on
it's-
many times, not
it's
saying
like-
available. Yeah.
Not possible to hear them.
Everything is covered.
Anyhow, I have to finish that.
Otherwise, Lordship, there are materials are there. Sufficient materials are there.
Yes.
And investigation is going on because other persons are also involved.
If we
Then
want to,
next-
if we have to hear the matter,
Pardon, I thought.
we're not in a position to hear the matter today.
Lordship.
So Mr. Chaudhary also has some, most probably some submission.
Hmm.
So I think you're finding.
Date at a date.
Date of মানে date
Date,
9.
date may be.
Yes, ma'am. Yes, okay. Complete one, and complete हुई हो तो आप किसी
23 की बात.
पूछा कि
Okay, then we'll list the matter on 23. This Tuesday.
Will it be written or Lordship update?
Written.
It's
This
written.
Tuesday only. This
Not-
Tuesday.
Obliged to Lordship.
23. Sorry, 23/6. List on 23/6, CDB written till next date. Okay.
21.
Mr. Poddar,
Lordship.
heard that CD received, but there are, you have not received the injury report.
Lordship, I suppose earlier it was rejected, perhaps.
Yes, it was rejected.
Lordship, I have also requested for calling of the earlier bail petition, rejected bail petition, where I have annexed, Lordship, one of my title suit records, Lordship, and the counter FIR, Lordship. There was a group class. I belongs to the brother of the
We are not
plaintiff.
in a position to hear the matter. That's why just I'm asking. You have received the case there. What is your submission? And the
Injury report awaited, Lordship.
Pardon?
Injury report is awaited.
Injury report is.
Yes.
Can you get the injury report by because 24, 25 most probably these days will going to list less numbers of matters.
Maybe on 24, Lordship, 25, Lordship. Because our side also several persons were injured, Lordship. I am not denying that group class, Lordship.
Your resection order dated 15/5.
Then may be taken up as a last item, Lordship.
25.
25, Lordship.
On the injury report, Lordship.
Call for the
CDB retained or
Heard Mr.
City,
S. Delaney counsel for the petition also. Heard MS SH Bora.
Lordship, may I be given some, considering my age, because I am a ailing person.
Hearing on behalf of state respondent, CDDC have already submitted to MS Bora that injury report is not yet received. Let CDB detain and the prosecution is hereby asked to call for the injury report and let the matter be accordingly listed on 25. We're listing it on 25.
Lordship.
Lordship, may I request for interim protection because I am a ailing person, Lordship.
25/6 we are listing.
No,
Somehow
just
we are
I
listing.
cannot go for medical checkups also. That's my problem, Lordship.
We were not going to hear the
Lordship.
matter. Just
Okay,
for
Lordship.
the time being only.
Okay, Lordship. I'm obliged, Lordship.
Item 20, my lord, I missed the item 20, my lord.
20?
There is the interim order was there, my lord.
Don't know.
Sorry, my lord.
It's already over all this. 15/7.
The interim order,
Interim,
interim is there, my lord. That may be continued.
it is awaited, na? Service?
Yes, Lordship, yes. Not, Lordship, no case has been registered against the petitioner.
We
Then-
were supposed to dispose the matter, but you were not there. That's
Yes,
why.
yes, I was in another court, my lord.
Noshad Ali Ahmed, no?
Noshad Ali, na?
Yes.
Yes, yes.
No case is registered.
Then my matter may be followed.
Yeah, under Bongaigaon, I think, na?
Yes, ma'am.
Lordship.
Order asking for hard Mr. You are Mr.
HR Ahmed.
HR Ahmed. Or so and so report received from so and so. When it is reported that no case has been registered under the Bongaigaon case against the president. Was there any interim earlier?
Yes, ma'am. No corrective action.
In view of this, the present petition is accordingly disposed of. However, the petitioner is at liberty to approach the appropriate forum of law in the event if any case is registered against him. The interim granted earlier is also here present. The report received from the police station be kept as a file. With the above observation, the present may be sent.
Lordship, there is a note from the IO Lordship in the state report because after getting interim protection, they have not appeared before the IO.
No, now we
There
are.
is no direction.
Lordship,
We have vacated the interim.
Yes, Lordship.
If they have not appeared, let the police what will do?
Yes,
I don't know.
otherwise
Because
Lordship disposed
there
of
was
the-
an interim protection was there,
Yes,
so they could have appeared before the IO, but in spite of that, if they had not appeared,
yes, that
then
they
they
have
did
not
not
appeared.
avail at that opportunity. The interim is already vacated.
Yes,
Yes.
Now police has at liberty what?
disposed of. the matter.
Disposed.
Yes,
Obliged, ma'am.
and the report may be kept as a
Kept
part
as
of
a
the.
part of.
Yes, highly
Obliged.
obliged.
Yes, Mr. Mishra, you can continue. Am
Please,
I
my
audible?
lord.
Mr. Mishra, you can continue. Yes.
Yes. Am I audible, Milos?
Yes, down.
Yes. Milos, I was showing from the additional document volume the arrest memo, Milos.
Yes.
I was arrested on 1st October,
110.
110 Milos.
Yes.
At page
110, though,
110,
as per the notice, you were asked to appear on 610.
610, please,
Right.
Milos. Now, 113 is the arrest memo
Yes.
of the additional document volume. Now, one thing is important which I want to show. Para 3, circumstances.
Para?
3.
Para 3 of your petition?
Para 3 of the arrest memo, Milord.
Oh,
Page,
okay,
one,
okay,
page
yeah.
113.
Ah.
The accused Shri Siddharth Sharma is a named FIR accused in the commission of grave and non-billable offence such as criminal conspiracy, murder and culpable homicide not amounting to murder. Material evidence collected during investigation including documentary records, financial transaction and witness statements prima facie establishes his culpability. Now, this is important. The statement of witness Shri Shekhar Jyoti Goswami, recorded under so and so BNSS, revealed that prior to the death of the deceased, a conspiracy was formulated to portray his death as accidental. He stated that Sri Siddharth Sarma, who stayed with him in room number so and so at Pan Pacific Hotel Singapore, had displayed suspicious conduct. Shri Shekhar Jyoti Goswami further stated that the accused forcibly took control of the yacht from its sailor, causing it to wobble dangerously in mid-sea, thereby endangering all passengers. He also revealed that Sri Siddharth Sarma instructed Sri Tanmay Fukan not to arrange drinks, claiming that he alone would provide them. During the critical moments when Sri Jubin Garg was gasping for breath, almost drowning, Siddharth Sharma was heard shouting, Jabode, Jabode, let him go, let him go. The witness emphasized that Jubin Garg was an expert swimmer who had trained both him and the accused and therefore could not have died due to drowning. He alleged that Sri Sharma and Sri Mohanta had poisoned the victim, which is not even the case of the prosecution, and deliberately chosen a foreign venue to conceal their conspiracy. Sri Sharma also instructed him not to share the yacht videos with anyone. When Jubin Garg was frothing by the mouth and nose, the accused Siddharth Sharma dismissed it as acid reflux and assured others there was nothing to worry about. Instead of providing necessary medical facilities, he facilitated the early demise of Jubin Garg. Now, next statement of Srimati Amrit Prabha Mahanta and Srimati Nishita Goswami corroborated that Sri Sharma had facilitated Jubin Garg's access to liquor and inappropriate company by arranging accommodation for Amrit Prabha in the same room with Jubin Garg of Pan Pacific Hotel, Singapore. The accused had failed to provide any satisfactory explanation regarding supply of liquor and women to the deceased prior to his death and the place of arrest and dated time. Now, one thing, Milords, which even I had argued before the trial court and which was not adverted to by the trial court, Milords, is that all these persons, the statement on which I was arrested, and also on the statement of whom Section 103 has been added to the charge of murder itself, are the co accused currently. Now, whether the question of law here arises, whether on the statement of co accused, would a charge of murder be leveled against me, which in its structure as per BNSS and the judgments, the law laid down by several courts, including Gauhati High Court and Supreme Court, is a weak evidence in itself. When a co-accused implicates others, it is a weak evidence. Now, if Milords will again see the Milords submissions in the impugned order of the trial court. The impugned order starts from, in the bail application, starts from page 62, and the relevant submission, Milords, is at page 66, 65.
Yes. Yes.
Yes. Para 4 at page 65 at the bottom, Milord. Learned counsel for the accused A1 contended that prosecution does not have a prima facie case against the accused A1. No prima facie evidence to commit the offense of murder punishable under 1031 of BNS is present against the accused A1, and section 1031 BNS is subsequently added on the basis of the statement of co-accused. No material of conspiracy, no material of meeting of mind, which is essential ingredient of the conspiracy, are present. Accused is not at flight risk. Accused was only manager of the deceased, thus he has no legal obligation to take care of the deceased, and those may be moral obligation, but same cannot be termed as negligence and illegal act, and may be only omission and no illegal act of the accused ever is present in the voluminous charge sheet. What legal duty imposed upon A1 as manager of the deceased is not disclosed. There is no material to show that A1 fed alcohol to deceased. A1 not pushed deceased into sea, and word jabode, jabode does not cover any illegal act, and accused one did not serve drinks to deceased. A4 stayed in the room of the deceased. Yacht was not under the control of A1. A1 could not come with deceased as that was a charter flight, and prays for grant of bail with any condition and further condition that A1 be allowed to stay in other place outside Assam as there is security risk for A1, and to provide security to A1 prays to pass such other order. Then, my lords, the submission of the learned PP is recorded. However, this point has not at all dealt with by the trial court, that whether the charge included the charge of murder under section 103, which was later included, is a weak evidence and it is not corroborated. Therefore, at the time of grant of bail, this factor has to be considered. Now, Milos, my colleague had have submitted some judgments to Milord's court master, whether those judgments can be.
Yes.
Please, Milords.
Okay, so Andrabi is there?
Andrabi, yes, Milords. That I will come later, Milords. If Milords will be Milords gracious enough to take case of P. Krishna Mohan Reddy versus State of Andhra Pradesh, which is of 2025.
Yes.
Please, Milords. It is by Justice Pardiwala and Justice Mahadevan. Has my lord got that? At paragraph 30, Milords, page 8. Page numbers are given on the left top hand side. paragraph 30.
Thirteen, 13 or 30?
30, my lords, 30.
Yes.
Please.
Yes.
Since the High Court has touched Section 30 of the Evidence Act, we would like to say something in this regard. The said provision reads thus: when more persons than one are being tried jointly for the same offense, and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes such confession. As per Section 5 of Evidence Act, only those facts or facts in issue which are considered relevant under Chapter 2 of the Act would be admissible as evidence. Then sections 24 to 30 of the Evidence Act deals with relevancy and admissibility of confessions as evidence. Section 24 of the Evidence Act provides when a confession would be relevant by laying down a negative rule of relevancy and prescribing the general parameters when a confession would be considered irrelevant, namely when such confession is caused by either threat, inducement, or promise. Sections 28 and 29 of the Evidence Act, respectively, are an exception to the aforesaid general rule of relevancy of confessions. Section 28 provides that where, although any threat, inducement, or promise was made to cause a confession, yet if such confession was made after the cessation, removal, or eradication of such improper influence or impression, then such confession would be relevant. Section 29, on the other hand, expands the test of relevancy by prescribing a positive rule of when a confession would continue to be relevant and provides that a confession made under one particular type of promise, that is, a promise of secrecy, or made as a result of any deception, intoxication, or by one's own volition in response to any question, would not render such confession irrelevant. Then, then below 33, paragraph 33. Section 25 of the Evidence Act goes one step further by providing that even if such confession is not hit by Section 24, that is, it is not the result of any threat, inducement, or promise, and thus considered relevant, still such confession would be inadmissible if it was made to a police officer. Section 26 and 27 of the Evidence Act, however, carves out an exception to this. Section 26 provides that a confession made by the accused to persons other than police officers would be inadmissible if it was made whilst he was in police custody, whereas Section 27 only permits limited use of such a statement only to the extent that a fact is discovered pursuant to disclosure statement which would connect the accused with the crime with authorship of concealment. Then this is important now. Section 30 of the Evidence Act provides that a confession made by a person admitting his own guilt and at the same time implicating another person, such confession may be taken into consideration by this court against the maker as well as against the person it is being made if both of them are being tried jointly. Then, my lords, paragraph 34 is about the Privy Council decision. Milords, I'll skip that. Then, Milords Kashmira Singh, paragraph 36. This court in Kashmira Singh versus State of MP further explained as to when such confession may be taken into consideration against another co-accused, placing reliance on the decision of Swamy. It was held that when there is evidence against the co-accused sufficient if believed to support his conviction, then the kind of confession described in section 30 may be thrown into the scale as an additional reason for believing that evidence. And the proper way is to first marshal the evidence against the accused excluding the confession altogether from consideration and see whether if it is believed a conviction would safely be based on it, if it is capable of belief independently of the confession, then of course it is not necessary to call the confession in aid. But the cases may arise where the judge is not prepared to act on the other evidence as it stands, even though if believed it would be sufficient to sustain a conviction. In such an event, the judge may call in aid the confession and use it to lend assurance to the other evidence and thus fortify himself in believing what without the aid of the confession he would not be prepared to accept. Thus, such a confession can only be pressed into consideration by the court as a rule of prudence to lend assurance to the other evidence against such co-accused. Therefore, the ingredients or conditions required under Section 30 of the Evidence Act before any confession is made to operate against a co-accused, that there must be a joint trial, it must be a confession, the confession must inculpate or implicate the maker and to the same extent the other accused. The confession of guilt must duly be proved. The aforesaid four conditions have to be strictly established. Such confession cannot be taken into consideration under Section 30, where the confession itself was not relevant or inadmissible, or where a co-accused was not being tried jointly with the accused persons who made the confession, or where he did not make a statement incriminating himself along with the accused. Then, Millers, I'll skip these paragraphs. I'll come to then final observation. At page 16, paragraph 53. Paragraph 53, 5.3. From the above exposition of law, the following emerges. A person who is accused of an offense or named in the FIR can be examined by the police and his statement may be recorded under 161 of CRPC. Second, a statement of an accused under 161 would ordinarily be of two kinds. It may be inculpatory in nature or may be exculpatory in nature. Then third, an inculpatory statement again may be in the form of an admission or a confession. If such a statement admits either a gravely incriminating act or substantially all the facts which constitute the offense, respectively as held in Pakalanarayan Swami, then it amounts to confession. Where such police statement of an accused is confessional statement, the rigors of section 25 and 26 respectively will apply with all its vigor. A confessional statement of an accused will only be admissible if it is not hit by sections 24 or 25 respectively and is in tune with the provisions of section 26, 28 and 29 of the Evidence Act respectively. In other words, a police statement of an accused which is in the form of a confession is per se inadmissible and no reliance whatsoever can be placed on such a statement either at the stage of bail or during trial. since such confessional statements are rendered inadmissible by virtue of Section 25 of the Evidence Act, the provisions of Section 30 would be of no avail, and no reliance can be placed on such confessional statement of an accused to implicate another co-accused. Therefore, my lords, here it is a fact, my lords, even my lords, we have challenged the order by which the charges have been framed. This argument has been rejected, my lords, by the trial court, saying that there are other materials and it is not on the basis of the statements of Shekhar Jyoti Goswami or Amit Prabha, who are the co-accused. Whereas the fact remains that Section 103 of BNS was added only on the basis of the statements of these accused, and that too under 161 CRPC. It is squarely hit by 25-26 of Evidence Act. Any statement given to police officer, my lords, which by a co-accused, even if he was not an accused at that time, but later when he is made an accused and his statement is being relied upon to implicate others in the crime, then my lords, it is hit by 25-26. This is what this judgment says, my lords. My lords, in that regard, my lords, I have also filed Kashmira Singh's judgment, my lords, which I will not read because Kashmira Singh has been dealt with by this judgment only. Now, in this regard, my lords, may I request my lords to see just one page in the trial court records, if it is available, my lords.
Yes, which page?
In the trial court records, I wanted to show from the relied upon documents by the prosecution, my lords. My lords had called for the TCR. If relied on documents are available, I'll just show one page, my lords.
This is a very voluminous one, so the trial court had given us in a form of pen drive. We can play it. Which page do you rely, Manju?
Volume.
Volume.
My lords, I just want the documents volume.
In volume? Which volume?
Documents volume is separate from the charge sheet, my lords. I don't know which volume. It is the D2, document D2.
D2?
Yes, my lords.
Now, in which volume it is there?
My lords, it is the document, relied upon documents volume. In the trial court, it is known as relied upon documents volume.
Probably it is in the index, man, not the first volume. Before the charge sheet and all, the chronological things are given. Yes.
So maybe in the first volume?
Only the charge sheet part. The volume is charge sheet. Thereafter start volume Roman 1 standard.
No, the charge sheet itself is in several volumes. Is till 8 volumes are the investigation report, and thereafter they are chain of custody and then relied upon documents and depositions, 161 statements. I'm sorry, Milords, if it is taking time, I will just brief, I will make a small summation about this document only.
Yes.
Milords, this document is an order of the learned AJS, and additional JMFC Miller, Judicial Magistrate First Class of Kamrup, of dated 28th September
Additional
2025.
CGM order dated.
Order dated 28/9/2025.
Yes.
Now, by this order, my lords, section 103 was added.
Acha, by that order. The order, I mean, prayer for IO was considered and the 103 was added.
Yes. Now, Millers,
Order if your lordship would like to see.
Okay. Yes, so this is the order, prayer for addition of 103.
Yes.
And the order was accordingly passed on 28/9.
Yes, Millers.
28/9. Order.
Millers have got that order, D2.
Mr. Kama, it is not the order, this is the prayer. Where is the order? Do you have?
It's all in that apartments.
Millers may not bother. Millers, I'll just read the order and Millers can.
This prayer was there, IO from the IO, but where is the order? On the basis of that, the prayer most probably the addition.
was around.
Can you tell us the volume, para, these things? Then we
Actually,
can.
madam, there is no volume. It is the charge sheet volume, madam.
Charge sheet.
Wherein everything is charge sheet for Ulale Papa. Thereafter, volume starts.
No, charge sheet is there, I can understand, but where is the order?
Madam, actually, we have submitted the charge sheet along with the relied upon document and all other documents. It's all compacted made. So if that bundle is looked into, then only your lordship will get.
Relied upon documents.
No, what generally what we do, these are the prayer, etc. These things.
These things
we
are
all
the
be
original
included in the.
It will be the original GR record, madam. Because before being session case.
Yes,
here-
there was a case.
There was a case.
So that order is
In the trial court matter, or we have to obtain the certificate. It is their duty here now. Everything is there.
It is document number D2. D for Delhi 2.
D2. Maybe D2, madam.
The folder's name is relied upon documents.
28/9/25.
कोर्ट मास्टर साहब, वो जब चार्जशीट की जिप फाइल को खोलेंगे तो उसमें एक रिलाइड अपॉन डॉक्यूमेंट फोल्डर होगा. रिलाइड अपॉन डॉक्यूमेंट. आई एम सॉरी मिलर सर्विस.
Next page. File. Yes, we have.
Obliged.
28
Obliged.
9 2025 order is here. And
Yes.
relied upon document in document D2.
Yes. Yes. Now
Yes. Yeah, please.
I'm obliged.
Yes. So from here, what do you want to submit?
Yes. In this order, my lords.
Yeah.
In the middle, second paragraph,
Mm.
during the course of investigation, the SIT has found out. Second paragraph, around 10 lines in the middle. During the course of investigation.
During the course of investigation, SIT found certain
Startling revelations. Now, may I read it, Milords?
yes.
During the course of investigation, the SIT has found out certain startling revelations in the statement of witness Shekhar Jyoti Goswami, recorded under 175 BNSS, which revealed that prior to the death of Zubeen Garg, a conspiracy had been hatched to portray his death as an accident. It is further revealed that accused Siddharth Sharma instructed one Tanmay Fukan and member of Assam Association not to arrange any other drinks, asserting that he alone would provide them. The witness was also instructed by the accused not to share the videos taken in the yacht. It is also stated that the bottle of black and white liquor, which is not available in Singapore, was given to Jubin Garg on arrival at the hotel lobby by Sham Kanu Mohanta, and witness doubts that something was mixed inside the bottle. The assistant investigating officer also stated that statements of witnesses like Srimati Amrit Prabha Mahanta, who is also a singer who was part of entourage to Singapore, and Nishita Goswami have also brought forth several important and corroborative facts requiring further scrutiny in this matter. Under such circumstances, the assistant investigating officer has prayed for allowing him to add section 103 of BNS along with already existing sections on which the instant case has already been registered. I have duly perused the case diary that has been produced before me and have heard the assistant investigating officer on his verbal submission, who further stated that section 1.5 of the BNS extends India's criminal jurisdiction to cover the offences committed outside the country, ensuring that Indian law can be applied to acts that would be punishable if committed by citizen of India, even if they occur beyond India's borders. He further submitted that if an Indian citizen commits offense of murder in a foreign country, they can be tried and convicted in India. I have bestowed my anxious consideration to the materials placed before me, as well as to the submissions made by Assistant Investigating Officer, who is a member of SIT constituted by DGP Assam in order to investigate the instant case in a transparent and time-bound manner. Thus, Milos, this is important, going by the statements of the witness available in the case diary and from the circumstances that have been brought before me. So, what circumstances? The statements of Shekhar Jyoti Goswami, Amit Prabha, Nishta Goswami before me, I am of the considered opinion that the provisions of section 103 BNS might be attracted in this case as revealed from the material produced before me. The investigation must go unhindered and shall cover every aspect to unearth the facts of the case. I do not find any impediment in allowing the prayer of the investigating officer as it will aid in proper investigation of the case. Having discussed that, the prayer of the investigating officer is allowed, and he is allowed to add section 103 of BNS in this instant case for the ends of proper investigation into the matter. Please. So therefore, if section 103 was added, Millers, I asked this question to myself, on the statements of the co-accused, who are the co-accused and facing joint trial currently, but they in their statement do not implicate themselves, but only implicate others. And also given before the police, would a charge of murder, we are at the stage of the consideration for bail, so on prima facie, would a charge of murder sustain, Milords? Because Milords have seen in Kashmira Singh, in the latest judgment of Justice Pardiwala, that dehoards this statement whether the materials are sufficient to convict the accused has to be seen. So therefore, whether a prima facie case is made out of murder against the accused. So that's one submission, Milords, on which I am seeking bail. Second, Milords, Milords will also remember that initially the FIR was only on section 61(2), 104 and 1051 of the BNS, which were negligence and culpable homicide not amounting to murder and conspiracy. There was no murder. Maximum sentence under negligence, Millers, is 5 years. The minimum sentence under culpable homicide not amounting to murder is 5 years, extendable to 7 years, or 10 years, Millers. Now, if Milords will see the BNS, if Milords, on my request, Milords will see the BNS Act.
550. 550.
Yes.
Minimum 5 maximum.
Yes. That is there.
Yes, no, on other point, Milords, I wanted to show the omission and the negligence, that the duty to care imposed upon me, Milords. Yes, if Milords will see section 3 of the BNS Act, three seven. Because I am charged under these, 3637.
Yes.
36 says, whenever an act which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, each of such person who joins in the act
Yes, yes.
Please, my lords. 3.6 I was reading. Whenever an act which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, each of such persons who joins in the act, so it is act, with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with that knowledge or intention. Very well, my lords. This is 149. Then 7, my lords. Wherever the causing of a certain effect or an attempt to cause that effect by an act or by an omission. The first time omission comes here, Millers, apart from the definition. So it has to be either an act or an omission is an offense. It is to be understood that the causing of that effect partly by an act and partly by an omission is the same offense. Now, what are the omissions, Milos? Illustration says, first illustration is A intentionally causes Z's death partly by illegally omitting to give Z food and partly by beating Z. A committed murder. Then Milos 8. When an offense is committed by means of several acts, whoever intentionally cooperates in the commission of that offense by doing any one of those acts, either singly or jointly with any other person, commits that offense. Then illustration. A A and B agree to murder Z by severally and at different times giving him small doses. I'm sorry. Please, my lords, may I continue?
Yes.
Yes, please. My lords. So, illustration A to 8. A and B agree to murder Z by severally and at different
No,
times.
don't make such illustration. What do
Yes.
you want to submit? Yes, just make submission. Illustration.
Submission is this, my lords. Yes, submission is this.
We are, time is going, na?
Yes, yes.
And
And
our vacation will be started from this 26th is the last working day for us.
I'm so sorry, my
Whatever
lords.
order or submission you have to record by this 2 days. Otherwise, it will be again created problem, and the order will be fixed after the vacation. That is maybe 17th or 18th of July.
No, no, my lords. I'm just
So I'm
finishing
saying
in.
try to cut short, make this submission to the point so that I can read the thing. You're stretching on the point of this 3.6, 3.7, 3.8 and all of BNS. I can understand why this omission and not think it.
Yes.
Okay.
In all illustrations, my lords, the emphasis is upon someone who has been placed under the control of Milos, the person who omitted, which resulted in death. Here, Milos deceased was not under my control. Being a manager, I was not controlling him, to restrain him, to prohibit him. If it was my duty to give him medicine, I gave him medicines. Medicine was found in his blood. If it was my duty, Milords, to fix his programs, to fix his itinerary, I was doing that. But to say converse that it was my duty to restrain him from not swimming or not drinking, my lords. This is a stressed explanation, my lords. This is the stressed reasoning. Therefore, this stressed reasoning, my lords, I cannot be kept in jail for that. Now, my lords, on the last point, my lords, I have given judgments on that tampering of the evidence. Amarmani Tripaঠি's judgment, my lords, for the time, my lords, I will not read it for the time, or if my lords want, I will read the relevant paragraph.
Yes, Amarmani Tripathi.
Yes, my lords.
Which
Which
para
is,
you want to rely, basically?
yes, 18, my lords, I'm sorry, my lords, paragraph 18.
Yes.
On Milos, for now, Milos, I'm sorry, just come to paragraph 18 is at page, Milos, page 11 or 31, paragraph 18.
Yes. Yes.
It is well settled that matters to be considered in an application for bail are whether there is any prima facie or reasonable ground to believe that the accused had committed the offence, nature and gravity of the charge, severity of the punishment in the event of conviction, danger of the accused absconding or fleeing, if released on bail, character, behavior, means, positioning, and standing of the accused, likelihood of the offence being repeated, reasonable apprehension of the witness being tampered with, and danger, of course, of justice being thwarted by the grant of bail. While a vague allegation that accused may tamper with the evidence or witnesses may not be a ground to refuse bail, if the accused is of such character that his mere presence at large would intimidate the witnesses, or if there is material to show that he will use his liberty to subvert justice or tamper with the evidence, then bail will be refused. We may also refer to the following principles relating to grant or refusal of bail stated in Kalyan Chand Sarkar, Milords. Therefore, Milords, I'll skip that. Therefore, a mere allegation without there being any substance in it that the accused may tamper with the witness or evidence or intimidate the witnesses, bail cannot be refused on that ground. There has to be a reason. There has to be a reason that I am a flight risk. The trial court wrongly records when there is material showing that he came to India with the body of the deceased. He stayed back. He wrote to the investigating agency that I am ready to cooperate. And he was arrested even before his date of presence. Milos, he is not a flight risk at all. He is not, Milos. In my respectful summation, he will he is not out to tamper with the evidence or intimidate. He doesn't have any personality or standing in the state to intimidate the witnesses. In fact, he himself is a victim, Milos. He has been attacked. His entire life is ruined, Milots. His house has been attacked. He himself is crying for security for himself. Then, Milos, on the third point that the public sentiments, Milos, I'll quickly come to Milos Prasad Srikant Purohit versus State of Maharashtra. Just one sentence, Milos.
Yes.
At paragraph Milos 31. In fact, I will read 28 also and 31. I'll read 28 first. At page 467, Milos. Paragraph 28 at the bottom of page.
Yes.
Conclusion. In our considered opinion, there are material contradictions in the charge sheets filed by the ATS and NIA, which are required to be tested at the time of the trial, and this court cannot pick or choose one version over the other. Liberty of its citizen is undoubtedly important, but this is to balance with the security of the community. A balance is required to be maintained between the personal liberty of the accused and the investigational rights of the agency. It must result in minimum interference with the personal liberty of the accused and right of the agency to investigate the case. The law, Milos, this is again the refusal. Milos, the same principles of law on the grant of bail. Then paragraph 30 is important, Milos. Before concluding, we must note that though an accused has a right to make successive applications, no, Milos, I'm so sorry. It is
31.
31. I'm obliged, Milos. At the stage of granting bail, a detailed examination of evidence and elaborate documentation of the materials of the case has not to be undertaken. The grant or refusal to grant bail lies within the discretion of the court. The grant of denial is regulated to a large extent by the facts and circumstances of each particular case. But at the same time, right to bail is not to be denied merely because of the sentiments of the community against the accused. Milos, with these submissions, Milos, I pray for the bail for my client Milos. He has spent now, Milos, more than 8 months. There are total 394 listed witnesses. My learned friend may correct me. 300, I'm sorry, sir.
395.
395 witnesses. Even though the trial is going day to 4, exactly. So I said 394. Even if the trial is going day to day, Milots, right now only formal witnesses and complainants are being examined. So total 10 or 12 witnesses have been examined till now. Milots, when the main witnesses will come, they are accused, Milots, several accused. The lawyers, the cross examination will go for long, Milots. 394 witnesses will not be over in 1 year or even 2 years, Milots. We have only 365 days, and that too minus Saturday, Sunday, and holidays. Milos, this trial with these many witnesses and such voluminous record is not going to end soon, even with day-to-day trial. In these circumstances, with such weak evidence, the charge of murder, Milos, I strongly, Milos, pray for the bail. Milos. Obliged.
Well, so for our part is concerned, my lord, actually there are instruction. Our Honorable AG Advocate General will appear in this case, my lord, and he'll address the court, my lord. So right now he is not in the state, my lord, in the country itself. So he'll be back by Monday. So can it be taken up on Tuesday? We'll finish it on Tuesday we'll finish it. We have noted down everything, we'll brief them. So it will hardly take an hour or so.
Mr. Mishra, will it be convenient for you to list the matter on Tuesday for their submission? The state of prosecution submission.
For our reply, Mr. Mishra.
For reply of the prosecution.
My learned friend is a special PP is not going to argue it.
Yes, our instruction is that Honorable AG will appear on behalf of the
Advocate General will appear. Very well, Milos.
We'll finish it up on Tuesday within an hour.
Very well, Milos. I have no problem.
So no issue for Tuesday, huh? We are taking a Tuesday date on 22.
22nd.
22nd.
No, not on 22nd. It will be 23rd, I think.
23rd, sorry. 22nd is Monday. Because we'll brief him, my lord, we'll take only an hour or.
It will be taken. No. Can- কোনোমতে নহ'ব ন। এইটো ক'বই লাগিব। Then yeah. So then what we'll do, because you know, Mr. Commander, we are next week is a motion week, in fact. However, we have to hear the matter this one. So we'll fix positively at 10:30 this matter.
Sure.
So you just be ready by 10:30.
He suggested, so why not that date that I said?
At 10:30 we'll do. There will be, will be asked to raise it to list lesser numbers of matters on that day, so that you take your time, because Mr. Mishra
Because
may.
I'm sure, my lord, he's smart enough to pick up things, so we have noted of everything. So we just brief him, and I'm sure you.
Basically, Mr. Mishra has already pointed out 3, 4, 5 points on the basis of which he made his submission.
We have.
Yes.
Do not going by the entire merit of the case, but these things are there only. So these 4, 5 points he have taken. So on the basis of that, you make a reply and all, we'll see to it. So we hopefully will list a matter on 23rd of this month. Positively at 10:30, we'll hear the matter.
Very well, my lord.
We start with the matter?
Yes, you start with the matter. If you have any reply and all, we'll give you some time to give a reply, if required. If not at all, it's not required. Okay.
That will be.
Very well, my lords. I'm much obliged.
Okay.
I'm much obliged for the patient hearing, my lords. My lords, despite of the VC.
Court is always patient, this court. My lord, we'll take the case. We have today, all the sheet matter coming making requested that we have produced the case that we have identified. And we'll take back and again bring it on the date.
Case diary to produce probability hard DTP, so and so. Mr. Mehdi is also there. You are also assisting?
Yes.
You are assisting? Yes. Mr. PP is also here? No, you are not there. Then produce the case diary.
For informant, he is appearing.
It's informant, please. For the informant, for the victim.
For the victim.
For the victim. For the victim, informant. Because informants, unless there are numbers of. One of the informant is also there. Okay, the informant victim. Informant.
One of.
So matter 10:30, positive at 10:30.
Yes. And the case diary thing is written.
Yes, we'll reach it. That the case diary is produced, and there was a direction to reproduce the case diary on Tuesday.
Tuesday.
Okay.
Much.